Yes, please.
I beg
Yes,
pardon,
please.
my lord.
Carry on.
My lord, item 13, my lord. On behalf of Mr. Pandey, my lord, Akshay Kumar Pandey, kindly taken up.
You are for the petitioner or the?
I am the petitioner, my lord.
For the opposition?
Already intimated to the SP Panda.
I am not party to that intimation.
My lord.
Please don't include the court.
My lord.
So you have to wait. Either the other side appears, they may object or they may not object. Did you intimate in my presence or out of court?
No, out of court I have intimated.
So don't
He has
do
no
that.
objection.
So don't. Very good. Both of you
My lord,
agree, sir. But
My lord, he informed me.
My lord.
I was there when you talk to each other.
No, man.
So then why
I'm
you are
sorry,
telling
I'm
that?
My lord, my lord, he informed me.
Item
21.
item
My
7.
lord, item 30.
ଗୋଟେ ସରୁ ଆଗ ଗୋଟେ confusion ରେ ଗୋଟେ ଆଗ ସରୁ.
My lord, after vacation, my lord.
After item
Because he has
30,
filed a affidavit.
ଶୁଣନ୍ତୁ ଟିକେ ଆପଣ ତ ଆର୍ଜନ କରିବେ ଏତେ କଥା କାହିଁ କହୁଛନ୍ତି?
My lord.
ଆପଣ କାମରେ ଆର୍ଜନ କରିବା କାହିଁ?
Item 17.
ଟିକେ ଆପଣ ନାଁଟା ଟିକେ ଆପଣଙ୍କ ନାଁଟା
Arun Kumar Naik on behalf of Mr. A.K. Pandey, Akshay Kumar Pandey.
ଅରୁଣ କୁମାର ନାୟକ.
My lord.
କେ ନାୟକ.
my lord, I am appearing for opposite party.
My lord. After vacation, my lord.
ଡେଟ୍ କରନ୍ତୁ. 8 July.
My lord.
If they appear and object, so it will not be urgent.
My lord, I am appearing for opposite party.
Preemptive mentioning and urging.
My lord, I am appearing for opposite party.
Item number 17. There are two matters. One, first matter, my lawyer friend Mr. Sai is saying that has become infructuous. I am not concerned. But the WPC number 12497 of 2020, I have received a counter on behalf of the
Item
CTA.
17.
My lord. 12497 WPC.
So what do you want?
I want that I will file a rejoinder. My lord will grant me some time and let it be.
What do you want?
I want to file a rejoinder.
When, sir? When do you want?
But I want it should be listed after vacation. In the meantime, I will file rejoinder. I don't fix any date after the losses conveyed.
Item 4.
ठीक है, sorry नहीं, गोटे सरला परे ठीक है अपेक्षा करो. Keep some. I have to take down what you are saying. All these things. 3rd July.
My
Other side, Mr.
Yes,
Swaying for the Staff Selection Commission.
Yes.
So the other matter, when it will be called, all the matters which have been mentioned, I am keeping note of that.
yes,
I will adjourn when the matter reaches. I will pass order. Without orders, it cannot be adjourned.
my
Item 4.
Or you have to wait. To wait, it will be called. If you are in a hurry, don't want to remain in the court, you can inform your.
I will file the affidavit saying the more.
ଆପଣ ଟିକେ ଅପେକ୍ଷା କରନ୍ତୁ ଆପଣ 4 ରେ ଅର୍ଡର ଡାକିବାକୁ ପଡିବ.
My lord.
I can't pull up file. Mr. Mohanty is appearing. Give the file. That is not the way to conduct a court. If you are not attending, then kindly request any of your friends. Yes.
Item 26. Lord, I'll file prepare a written note of submissions, my lord, because my lord, the pleadings completed.
Yes. What do you want, Mr. Biswan?
My lord, 2 weeks time, my lord, I will file the written note of submissions.
Written note is not required. You want to argue, argue. The court doesn't require any written note.
Because
you can submit based on your written note. So why should I record that I require a written note? It should be adjourned.
No, my lord, the date chart and the
Whatever, sir,
judgment,
date chart
I have not prepared.
Yes.
I have not
You
prepared that.
confine to pleadings. You are not prepared. You say that. How
Well,
you are preparing? I am not
I have
concerned.
2 weeks after that.
2019 matter.
My lord.
State. Any objection?
No.
Yes, Mr. Biswan, when do you want?
Any day, my lord.
Any day is not available. I have
After-
been searching the calendar where any day, my lord, please. These dates are not there. Monday to Friday. 7th.
My-
साथ.
Item 36, my lord.
Yes.
Item
Can you speak to
36,
the microphone? 36.
my lord.
36 कौन है?
A transfer petition, my lord, at instance of the petitioner.
No, don't argue on merit, sir. It is
My
not
lord,
reached.
my lord, I
You are
pray.
yet to call item 1.
Pardon me, my lord. Conducting counsel, Mr. Behra is having some personal difficulties, so I pray
What is
for
your name, sir?
SS Panda, Sanat Sushoman Panda.
You have power here.
Yes, your lordship.
Who is for the other side?
None have appeared, my lord. Notice.
So 8-7. It will be taken up when it reaches. I have noted. Yes. Next.
My lord.
My lord, item number 37.
Yes.
Permitted to withdraw. The opposite party not appeared. In the meantime, they have settled their dispute. So,
File a memo. File the memo.
my lord, I have ready with a memo, my lord.
Yes.
Lordship, item number 15, Lordship.
1-5.
1-5. I pray for some time, Lordship. Let it come after vacation.
Your name?
Meenakshi Jaina.
Meenakshi Jaina.
We have taken the consent of the other.
I am for the opposite party.
Sorry.
I'm for the.
Yes. You are for the other side.
Yes, yes.
What's
your
your
lordship.
name?
Shivam Misra, your lordship. But I don't have power on behalf of Miss S. Patnaik.
Subha Patnaik.
Somalin Patnaik.
Only. After vacation, you want?
After
9th? 9 Yes.
Lordship.
Any other? Call the list.
Item
Item
13.
1.
Lordship, item
Item
number
13.
14 also. Your
Sorry.
lordship. Item number
Just a
14.
second. Item?
Item number 14.
1-4. Yes.
Will file a wakalatnama on behalf of OMC.
So it has to be recorded. It has to be recorded unless the order is passed. Can't be. Out of turn, when the matter is mentioned for adjournment, it is expected that it will be simply adjourned, or a date is given, or order has to be passed. After notice matter, I cannot adjourn like in absence of the petitioner. You have to wait. Or if you do not want to remain in the court, you can request any of your friends.
Lordships.
You have filed wakalatnama when? Your name is there? RK.
No, Lordship, on
Pamira.
behalf of Miss Pamira, ma'am.
What do you want?
Let it come after vacation. We'll file a wakalatnama on behalf of OMC.
Acha, yet to file your wakalatnama.
Yes, yes, Lordship.
Third June.
Lordships.
ମୋ ପାଖରେ ଅଛି ମ୍ୟାଟର ଆର୍ଜନ ହେଇଛି କିଛି ଲେଖା ଅଛି ଆପଣଙ୍କ ପାଖରେ ଦେଇଛନ୍ତି ଆପଣ item 14 sorry 3rd of July
3rd of July. Lordships.
Item 13.
yes 1-3
Item 13, petitioner informed me for adjournment. Your lordship already adjourned the matter.
yes yes it will be it will be dictated when the matter reaches.
Yes, my lord. Petitioner informed me.
Yes, he might have informed you or you have informed him. That's different thing. That's not. So that's not my lookout. Who informed who?
Yes,
I am
yes.
confident that I am not party to that.
Yes, yes. No, your lord.
Yes. So it is after notice matter. It will be adjourned. No difficulty. No difficulty.
Yes, ma'am.
Otherwise, the court's work is full. That's no difficulty that some matters are adjourned. But
Yes,
not
yes.
this way that preemptive adjournment without informing the other side.
No, my lord.
In
Your
some
lordship,
cases,
your lordship, since hearing that pattern matter.
Now, you are not there in the VC. So how could you know that it is mentioned?
No, I am there, my lord. I am there.
You are in the VC, so you should have said that. It would have been nice to see you from in the VC. We didn't say anything, utter a word even. Yes.
I don't know one.
So Mr. Panda, the date is 8th of July.
Yes, yes, my lord.
By
Yes,
mistake,
yes.
I am at times saying 8th June, but it is 8th of July.
Yes, my lord. Yes, yes.
Could you hear the date, Mr. Panda?
Yes, yes. 8-7.
8-7. Yes.
Yes.
Yes, item 1. Mr. Pereira.
Item 1 minutes, Lordship's by order number 18 has directed to take instruction because our submission was the amount has been paid at the rate of 50,000 per acre.
Yes.
But my lords, as per the impugned award, it has been directed to pay
No, no,
as
kindly read that order. Kindly read that order. There is no reference to any amount paid or anything.
yes, my lords.
Coordinate bench on 21st of November 2024 has observed that the state is directed to obtain instruction from an appellant
Yes, my lords.
as to whether cause of action still survives or not.
My lords.
So you have received instructions.
Yes,
So,
we have got
so
a
whether cause of action still survives, that you have to state, or we proceed with the matter.
My lords, that we have not got a detailed calculation sheet. We need further instruction to.
Calculation sheet will not help you.
So
If
that
you
is
have
what.
challenged the order and satisfied the decree,
Yes.
then that's
Well,
the short point. If the cause of action is not there, in the sense you have already satisfied the decree
And my lords,
in favor of the claimant.
My lords.
It is a section 18 reference.
My lords.
So after the order is passed by the referral court, you have suppose you have paid
Yes.
or you have agreed for a settlement.
My lords.
So that way,
So my lords, we have.
in fact, I didn't pass that order.
My lords, may I submit my lords?
So kindly, you have that order.
Yes, my lords.
Paragraph 3.
Paragraph 4, lordship, may- page 3, paragraph 4, lordship, may kindly. May I place my?
Yes.
My lords, paragraph 4 is learned ASC submits that the compensation amount has been calculated
No, kindly.
at the rate
you
of
are
rupees.
reading something else. I don't want to listen from you what is paragraph 4. I want that what I have observed in paragraph 3. This is LA 52. No, I would have
Yes, my lords, LA 52.
That is internal page 2.
Yes, ma'am.
Para 2 is appeal is heard. Then read thereafter.
Yes, ma'am. The appeal is heard. Learned ASC submits that the conclusion arrived by the referral court under section 18 of LA Act, Learned Civil Judge Senior Division Kamakhya Nagar in LA MC number 29 of 2005 is contrary to the material on record and also not supported by any evidence. Thereafter, my lords, any answering the reference issues have been framed at paragraph 4 and the judgment as quoted herein. 1. If award of compensation as passed by the LA collector is improper, inadequate, or unreasonable, warranting an interference by this court. Issue number 2. What relief the petitioner is entitled to. Learned Referral Court has taken note of the statement of the witnesses on behalf of the land outstee petitioner, as well as the statement of the witnesses produced on behalf of OP land acquisition collector. The exhibits produced and marked on behalf of the opposite parties, that is Exhibit A and Exhibit B, were also considered. The discussions thereon are reflected in the judgment at paragraph 6, which are reproduced here in my lords. May I read that one?
You have to.
Yes, ma'am. I'm obliged.
I don't have to request you again and
Well,
again.
well, I'm just taking a lordship permission.
Yes. No, why should you?
Well, let's.
Is it that while reading each page, I have to grant you permission? No.
The witness exam.
Because when you are submitting, you are not referring to the last order. That is how
Yes.
I requested you.
The
to read it,
witness
then you can make the
examined
submission.
by OP admits not to have got any direct knowledge about the present land acquisition proceeding. He also does not claim to have got any idea about the situation or prevalent market price of similar kism of land. He, however, has produced a copy of the working sheet prepared by the then zone officer wide Exhibit A and a copy of the cell statistic wide Exhibit B. A perusal of Exhibit B would reveal that the case village there were a number of cell transaction of Sarada Dui Kisam land during the year 2000 and till April 2002, and the rate of price remained stable between 77,000 and 78,000 per acre. There is no dispute before me that the present case land also the land covered by Exhibit 1 situated at the same village and were acquired by the state pursuant to the same notification dated 27/2002 wide Exhibit 1. This court, for the reasons cited, has determined market value of Sarada.
So you have marked the date order line portion.
Yes, ma'am.
These sale transactions were prior to the date of acquisition.
Yes, ma'am.
You are contending that these are post acquisition.
My lord.
So factually, you have showed nothing in the appeal that these transactions were post acquisition.
My lord.
Then kindly read further.
It is the
Video Exhibit 1, this court for the reasons cited has determined.
this court for the reasons cited has determined the market value of Sarodhar 2 Kisam land at the rate of 75 per acre. It is the settled principle of law that an earlier decision of the court may afford a good basis for determination of market value in a subsequent case of similar nature, having regard to the available material on record. And in the circumstances, in my opinion, the present petitioner is entitled to compensation at the same rate as determined by Exhibit 1. To put in other words, the land value is determined at rupees 75,000 per acre. The petitioner, however, could not establish his claim towards any damage on account of alleged severance of land, hence ordered. The learned ASC submits that the compensation amount has been calculated at the rate of 50,000 per acre, has been paid to the land outreach petitioner for his 0.6 decimal of land as per the instruction received. Further hearing, he seeks accommodation to obtain instruction.
So the hearing was concluded. That is how it has come to be mentioned. If you still want adjournment, I will adjourn. But you have to show something in the appeal that I can interfere. What is your best point? I mean, this was heard that day. This is after notice matter. What is your best point? May not be today. You make up your mind. Actually, the problem is that at times, I mean, maybe the court, maybe the lawyer. I don't want. I'm not blaming anyone. Please don't take it that way. But we are not. Since 2009, for the last 16 years, this matter is pending. What is the point to be adjudicated by the appellate court? And I mean, looking at you and knowing you, you are most competent to handle this question, to answer this also. And you have to make up your mind. So this submission that was recorded in November 2024. That whether cause of action survives, that is a one way. But even if you have filed an appeal,
yes,
for 50,000, you have given.
Right. Yes.
The court comes to a finding looking at the calculation sheet
74
and this somewhat concurrent sale deeds, that it is 75,000.
Yes.
That you do not dispute.
No.
Here, the court has relied on your witness.
My lord.
So what point remains to be adjudicated?
That, yes.
In the appeal, and that is kept pending for precisely 16 years.
I want one opportunity
Definitely.
to discuss with
For that day also, after passing this order, I still granted time.
My lord, sir.
Prabhu Prasanna Behra. Kepe ଚାହୁଁଛନ୍ତି?
My lord, just reopening week, can you do it?
Reopening ରେ କାହିଁ ଏଟାକୁ ରଖିବେ? ଆପଣ 15 ବର୍ଷ ରଖିଲେଣି ତ କିଛି ଏପର୍ଯ୍ୟନ୍ତ 16 ବର୍ଷ sorry 16 years ପରେ we have achieved nothing out of.
I will ensure that it will be. I'll address your lordship.
What is there to be ensured? Order number 18 is the judgment.
Yes, my lord.
Order number 18 is the judgment.
I just want to verify.
So only requesting, rather court, I decided that I'll grant you a chance. If anything you have to answer on this, the finding of the learned referral court, then you can answer.
Well, I require
you can reopen the material, whatever is on record is there.
Yes.
For the appellate. Respondent at a notice issue in. Notice to issue each other. If you did not put nothing. Done for the respondent none. The postal tracking report confirms that the notice has been served on the respondent in his address on 4th March 2024. The address given in the appeal memo is same as that of that address given in The judgment rendered by the Lorded Trial Court in LA Miscase number 29 of 2005. Following PC Alavi Haji versus Pallapatti Mohammed Supreme Court decision that and decision rendered by the Supreme Court in Hindu Bhushan versus Munna Lal. Into bracket 2007 14 SEC 42. Into notice shall be treated to be sufficient. The learned AC refers to the order dated 23/4/2025 and submits that he may be accommodated further to obtain instruction and advance arguments. Yes. Reparivo, Chutti Purvuru.
Yes, ma'am. Right.
Kebe.
15 minutes.
I'll spread for list on 15 May 2026. Therefore,
Yes.
because you to make up your mind, you can. Yes. Yes, please next.
Item 2.
Item 2, there is a 13 petition and there is a 9 petition. So that day, in fact, you are in receipt, so you did not point out that these are interrelated. But yes, they can be taken up separately. There is no mandate of law or case law that the items have to be taken
Because
I
both
mean,
are in
together.
different stages.
So the query is that yes, the order has been dictated and it's correct order also. It's not so difficult. But have you considered that aspect 13 and 9 for both of you? Would it not be convenient for the matters to be taken up? And for that, maybe the usually the wife's place of choosing this is Cuttack and Bhubaneswar.
Yes, sir.
One is at Cuttack, one is at Bhubaneswar.
Yes.
So the wife has chosen, I think, Cuttack or
Yes.
Bhubaneswar.
Well, wife has started the proceeding of CRP, that is 125 at Bhubaneswar in the year 2017.
Now she wants it to be at
Now she wants it to be in
Cuttack.
Cuttack.
So 125 when she was staying in Bhubaneswar, she can file. 126 is very clear. And I'm yet to find any, there is a decision that it is better that all cases should be taken up together.
But in
Yes.
one,
So only to that extent I seek your assistance.
yes, my lord.
So can it come another day or we should close it?
My lord,
My lord, it may be over as
After
in
vacation.
one
Kindly speak to the microphone.
in the matter.
ठीक है microphone रे बोल आपण ओम स्वरूप.
ଆଜ୍ଞା ମାଇ ଲର୍ଡ ମ୍ୟାଟରରେ ସିଏ ଗୋଟେ ଡିଫିକଲ୍ଟି ଯୋଉଟା ଦେଖଉଛନ୍ତି କି ଯୋଉଟା ଡିଫିକଲ୍ଟି ତାଙ୍କର ଯୋଉଥିପାଇଁ ହେଇପାରିବନି ସେଟା ପାରା 7 ରେ ଅଛି
Mr. Om Swarup, there is the difficulty part. I am not adjudicating or going into that kind of detail. This is only offshoot of the existing proceeding. You fight out even the choice of the litigation, place of litigation. One is at Cuttack and Bhubaneswar, still you are fighting out. So that is the saddest part of it. So I am not going there. My question is different. So if you are not, I hope you understand what I am saying.
my
Then
lord,
why you are saying I can record as the 125 she has filed in Bhubaneswar. Now Cuttack. So now I have not interfered with your petition or his petition.
yes,
So both remain, the places remain as it is.
yes,
But only issue is that since 13 and 9 are interlinked. So what is your response to that? You
Hello.
obtain instruction, take short adjournment, it can come on.
Yes, yes.
no, my lord, as per my instruction, since conciliation have failed on several attempts before in
Sir, that I have recorded. If you remember that I have recorded in the order that even the
So there is-
litigation at High Court has failed and the matter is kept pending for since more than a year for nothing.
so there is no scope for section 9, my lord.
Scopes of section 9, are you addressing the family judge or the High Court judge? I'm at times I'm astonished.
My lord,
Are you arguing the section 9 petition? Then why there is scope of section 9 or there is scope of section 9? I will prejudge and direct that section 9 should be dismissed. You have to be responsible. And in these matrimonial matters, whatever the party says, don't go by that. Then why there is Hindu Marriage Act?
My lord,
Whether section 9 scope is there or not, whether section 9 will be, adjudicated, the court may still direct. Is it that section 9 is at the option of the parties?
my lord, in that case, it may run.
Swarup 9, it's a question on law, you have to answer.
Okay, my lord.
Section 9 is to be adjudicated at the option of the parties, consent of the parties.
No, it can run.
Never. Section 9 is for the court. Court can say that, yes, you have to restitute the conjugal rights. It's for the party. So, the strategy is somebody not complying with the section 9 order for restitution. That can be a ground subsequently as far as the divorce is concerned.
Yes,
So, it is not at the option of the parties the way you are saying that there is no chance. Section 9. Section 9, there can be mediation. The parties can agree to stay together. Look at it. That concept is also not correct. That is yet to develop at least. There is no precedence on that. Section 9, if one of the parties agree or the other party do not agree, then that will abide by the section 9 order of the, the court has to follow that. Court will adjudicate and say that there is sufficient ground, the restitution order court will pass. Anyway, that's not besides the issue. The order to draft order, let's see that. I have some difficulty because my court master is on leave.
After vacation.
After hearing from both the Lord and Counsel, there is no point in actually talking about any kind of agreement. Appearance has same order pass. The matter is taken up to be mentioned. Same order. So you prosecute your respective petitions at one at Cuttack, one at Bhubaneswar.
Yes, ma'am. Yes, ma'am.
Conciliation could happen despite pendency of and stay.
No, ma'am.
When the CP was initiated?
CP was initiated in the year 2023 after 6 years of initiation of section 125.
You are obsessed with section 125. Whatever you say, any question, your one single point answer. Section
123. In the year 2023.
The question is very simple. When the CP was initiated and whether conciliation could happen at all. Because the strategy is after the notice is issued, the parties come to High Court and get a stay by filing a TRPC. So that is the again you are going back to 125 TRPC.
In the year 2023, it was initiated. Conciliation
So how many rounds of counseling happened? Are you aware?
I was there in the about 5 to 6 conciliation was there, but all failed.
Same order.
I don't know 3.
Yes, anything you have to say, Mr. Mahanti? I'm sorry, Mr.
A.K. Jain.
Mr. A.K. Jena, you have to say anything?
My lord, my problem
is petition board for petitions fine.
My lord, I have a small child. He's 6 years old. He's studying here. A schooling problem, and I am also.
Microphone
My lord, I have a small child. He's
both
6.
of you, sir. Both of you.
Yes, ma'am. But
So-
child is with me. He's
Exactly.
6-7 years old. He's pursuing his study at school. So I have to take care of her. So I am also working in a college, my lord. So timing is very difficult for
So
me to
is it
attend
that
at
the
Bhubaneswar.
child is to be taken at Cuttack, you take to the court, and in Bhubaneswar, child is to be left at her or his place. The child is not a kind of pawn to be used in the litigation.
My lord.
It doesn't improve your case in Cuttack and Bhubaneswar. You must be going to now where you are staying.
I am staying at Tulasi. Yes.
Cuttack, you must be traveling to Bhubaneswar. Because now it is the habit of Cuttack people to go to Bhubaneswar and must be moving with the child. But obviously not to the court. Suppose it is you want at Cuttack. So at Cuttack also you will take the child to the court.
No.
Or you will seek accommodation in the adjournment in the court because the child has gone to school. What you are saying? These kind of, propositions advanced by the learned counsel is definitely bereft of any substance. No reference to any kind of any procedural law like CPC or Family Court Act and Rules or Hindu Marriage Act. This is only recital of whatever you are listening from your client and not thinking about anything. Not thinking. And wherever you go, the case must follow. That is the other theory that is being propounded. You choose at Bhubaneswar, case at Bhubaneswar. Come to Cuttack, case at Cuttack. There is no distance. Even the lawyers, you can also manage it. I tried to, get something or at least to convince the lawyers that was the whole effort that anything can happen. That order, both your cases will be one at Cuttack and one at Bhubaneswar. And one thing, when you are staying at Cuttack, is it that you are at your matrimonial home or you are at where you are staying at Cuttack?
Cuttack is my parents, not matrimonial.
Parental home?
Yes.
Obviously, for that reason you are staying at Cuttack. And why you are bringing a child into the picture? The child will grow and grow up definitely, and the child will at times ask you. You will have to do very difficult questions for a child, from the child to answer. Those things are not actually in the whole fight between the parents. Those things are not, become, they pale into insignificance. Yes, item 3, item 3. So, Sahoo?
May I please, your lordship?
Yes, please.
Why be the petitioner, your lordship, seeking transfer of the divorce petition from Balangir to Bargarh? Husband has filed the divorce petition, your lordship.
So after you have received notice?
Yes, lordship.
So before conciliation to the High Court, have you attended conciliation?
Kichi order hai nahi hai.
So why this strategy? Why you are frustrating the Hindu Marriage Act? The statutory mandate of Hindu Marriage Act that should be mandatory conciliation.
Conciliations divorce proceeding re appear kala pare hebo.
So you have come to court not to appear. See the last matter. For last 2 years, nothing has happened. Mr. Jagabandhu Sahu for the petitioner. You want from which place to which place?
Balangir to Bargarh, your lordship.
Your matrimonial home is at Balangir. You are married at Balangir.
My lord.
Submitted that petitioner wife prays for transfer of the proceedings. CP number. Mat suit. Title.
My lord, CS matrimonial number 15 of
CS
2000.
into bracket matrimonial, bracket closed, number 15 of 2025. Pending before the learned judge, family court, Balangir to learned judge, family court, Bargarh.
My lord.
He submitted that after the marriage ran into rough weather, the petitioner wife stays with her parents
My lord.
at Bargarh.
They were residing at Balangir.
Bartaman koti rauchanti.
Bartaman Bargarh district rochi.
Am I not audible? Subuchi to?
My lord.
O katha ta apono subuchi.
Subuchi.
This will improve. Next week, this will improve. Into rough weather. Bartaman Balangir rauchanti. Apano ground kono seeking transfer.
Bartaman Bargarh re rochi.
Bargarh rauchanti.
Ha bapa sangre.
Parents with Bargarh. ठीक है. She is facing difficulty to attend the matter at Balangir. Para. Issue notice along with this order. Requisites for issuance of notice by speed oblique registered post with ADB filed within 5 working days, 3 working days. Within 3 working days. List after SR, liberty to mention for listing before the assigned bench. IA 110 of 2025, issue notice as above, accept one set of process fee as well as postal requisites. Yes,
Lord, tomorrow is the date for appearance, your lordship.
you take steps, seek for adjournment. The learned counsel submits that tomorrow is the date of the date of appearance before the court after issuance of notice. Since the court is yet to proceed in the matter, the learned counsel shall the learned court the petitioner shall seek for adjournment, which shall be granted. This whole process of frustrating the Hindu Marriage Act doesn't work. The litigation for transfer of the case, whether the matter to be taken up at Bargad or Balangir, will take years together because you will never agree. You will not agree. That's the difficulty. The adjournment upon list on कर दियंतु जोड़ा ऊपर लिखिले list after जोड़ा कर SR कर दियंतु on कर दियंतु on 1/7/2025 तापर जोड़ा लिखले नहीं shall seek adjournment and the adjournment shall be granted beyond 1/7/2025. Yes.
Are you upload or not?
Do not hear, sir.
Upload. Are you ordered a copy? Urgent copy. your lordship.
चेष्टा करा जाउछ.
But-
I may not be that efficient. So, but still trying.
Item number 4.
Mr. Suraj Mahathi, my lord, he requested to make a prayer
Yes,
for
he
your
mentioned.
justice.
Mentioned. Mr. Suraj Mahanti for the petitioner. Mr. Sanjeev Swain, AGA for the state. On 1/5/2025, the following order was passed after hearing the learned counsel for the petitioner. Today, at the stage of mentioning, before the court proceeding started, the learned counsel for the petitioner sought for adjournment, which was not granted. When the matter is taken up, he doesn't appear.
He requested me.
Mr. Jena,
My-
Sashibhushan Jena, submits that he has instructions from the learned counsel seeking adjournment. Once the adjournment was refused at the beginning when mentioned by the learned court, when mentioned by the learned counsel for the petitioner, he has the responsibility to remain present when the matter is called. Be that as it may, to grant further opportunity. List. आज कितनी तारीख अछि? 7. List on 8/5/2025 to be mentioned. Mark as to be mentioned. Mr. Jena, I have some difficulty in forgetting actually. Whole problem is that
His calls here requested me to make a prayer before.
once the order is passed,
Yes.
once the order is
But I
passed,
do
we
not know
want
what
to
is the
avoid.
matter, but he just requested.
Somebody wants to avoid it, become bit difficult because I have some difficulty in forgetting. So that is the difficulty.
He was here, just he requested me. That I pray.
No, sir, that I have recorded. If you find anything incorrect recording, so that I'll definitely correct. Yes, Mr. Swain.
It will come.
Kali SU to be mentioned.
There are long arguments. They will dispose of our things.
We will file an
No,
affidavit.
you see,
Because-
that day, the order is very clear. Are you aware of the order?
Yes, I think.
Yes.
Correctly order has been passed.
No, correct or wrong, I should not say that my orders are correct.
It is a correct
Cannot be
order.
taken up next week. in
The whole
midnight.
thing is that your CMA appeal is not listed, therefore he has approached this honorable court for interim order.
You
So
see,
now it's
I-
3 months
I-
gone.
Not only that, I cannot I cannot.
Yes.
I cannot.
So
interfere with the
in the
business
meantime,
bench
let him
order,
take steps for listing of the same appeal.
whatever.
Yes.
Whatever.
That is the whole case.
So that he can very well say when the item 4 reaches, no difficulty.
Yes.
What is the point in coming and telling the court that I will not appear? So I refuse adjournment. If the lawyer chooses not to appear, is the court bound that court will not take up the matter?
Okay, let it come
That
tomorrow.
is, I have not
on-
understood from both of you.
Yes.
Both of you are seniors at the bar. I have never not understood that.
Yes.
Can it be taken up next week? You'll file an affidavit, he was just saying me.
No, let it come tomorrow.
I know, man. As you know.
Tomorrow.
As you know.
So let it come tomorrow. In the same heading, the fresh admission as well. To be mentioned with the fresh admission.
I don't know, 5.
Affidavit. Rather, this creates that if you what Mr. Swine has said, you have heard it. It affidavit of कौन करियो?
And more analysis just not right. I do not know what is the case about.
Exactly. There is a dismissal order by the division bench. So division bench order, how I will pass a order that it should be stayed. I mean, in fact,
In the meantime, from the date of dismissal of his writ applications, 3 months gone. In the meantime, he could have listed the same appeal for restoration.
And
That he has
only that suppose he approaches the authority, the authority doesn't pass a order.
so only for the purpose of satisfying the authority, this application has been filed.
But the division bench order dismissing the petition stares at the single bench.
So restoration by file କରିଛନ୍ତି. That is pending. সেটা list को आना.
And last occasion,
Without
the Lordship suggested the council for you file an application before there and file it here. Right?
So ତାହେଲେ ଗୋଟେ କିଛି କରିହବ at least କିଛି ଗୋଟେ କରିହବ ଜଣେ ଭାବି ପାରିବ ଯେ କଣ କରିବ. Once I know that there is a division bench order, I will pass a order that because my order staying any proceeding before in that certificate proceeding directly is contrary to because the division bench order. The appeal in the division bench has been dismissed.
Yeah.
Post that division dismissal, there is a order by the certificate of authority. Single bench will direct that certificate of authority will not proceed. But certificate authority is bound by the division bench order.
No.
I don't know, 5.
My lord, item number 6, my lord. My lord, item number 6.
I am therefore respondent.
5 state.
My lord, item number 6. I have filed an CMAPL for a restoration of the WPC number
After
31 of 2023.
Mr. Dev,
Mr. Bear.
Mr. Behra, Mr. Prabhu Prasanna Behra,
On 22/12/23.
Additional standing counsel for the appellant. You are sir for Mr.
For the respondent.
For the respondent, correct, on consent. List. List on 3 sir. ଆପଣଙ୍କର 23 ରେ କଣ order 21 ରେ କଣ order ହେଇଥିଲା?
Mr. Joshi last part. Mr. Joshi learned counsel for the respondent seek accommodation to verify the dates in light of direction of the Honorable Supreme Court regarding condonation of delay. So it is COVID period taken into consideration. He is contingent that whether limitation petition is required to file or not.
It has to be condoned, Mr. Joshi.
No.
That matter, yes.
Here, impugned award was passed on 21/1/2021.
Fair enough.
It was filed on 4/12. They have shown it a delay of 14 days. Here, as per the section 74 of the Act.
Sir, again, we are going somewhere.
Oh, yeah, yes, no. This morning I have got the copy of that COVID-19 guideline. That is
Supreme Court order.
whether it will cover the entire COVID period or not. That is to be examined. Because it was for 15th March 2020 to 14th March 2021.
What is
Award was passed on.
Mr. Joshi?
Yes.
What is the number of the
That MA number
before the
6.
Honorable Supreme Court?
My lord, MA number 665 of 2021. Miss Appeal number.
Supreme Court passed order for condonation of delay. In which order? You are
Basically,
saying I'm having a copy.
yes, I've got the copy.
So what is the number?
SMWC number 3 of 20.
Yes, so WPC number 3 of 2020.
So that, for that you took time.
Yes, let's keep it after vacation. I will examine.
No.
Eh?
This cannot be a Supreme Court order. You will examine it after vacation and the court will grant time.
Oh, that's all right.
Mr. Joshi, I have to record that.
Let's keep it after vacation.
Why should I? The IA for condonation of delay, I will keep after vacation.
An application need to be filed along with the appeal memo, my lord.
No, you have not. So that is why I am saying that which part of the Supreme Court order, you just look at it. You are saying that you are having that copy.
Copy ଅଛି ମୁଁ copy.
That's the problem.
Okay.
You may disobey Supreme Court order. Can the court single
No,
bench or then?
I will not dare to do that.
And then you are saying that you will file, somebody will file petition, something will be considered. Then what is the point of Supreme Court directing that the delay will be condoned?
Along with the
So
appeal memo,
suppose-
an application need to be filed seeking for condonation of delay.
Which part of the Supreme Court order I have been asking, sir? Thrice I have asked you, sir. You are just tapping your mobile phone and looking down, not answering. Which part of the Supreme Court order directs that they have to file a petition for condonation?
On next week as well.
Next week, tomorrow. First of all, you have not seen the order. That's the problem you are struggling.
Okay, I will get it.
You are getting SCC order anishanti. Dar ki sampark nahi. In re-contagion, the PIL where Supreme Court directed that it has to
Then
be.
you will keep it next week.
It is a 142 direction by the Supreme Court directing condonation of delay.
Yes, I will examine. Yeah, yes.
Ithere examine kis kari hoban.
You let's keep it next week.
Next week.
So that.
Joshi, you are just simply, dragging it.
No, yeah, more say no, intention say no, sir.
Which on the order, I am asking you, suppose there is
Yeah.
direction by the Supreme Court that they have to file application. So I will direct that. You are yourself, you are tentative. You are not sure. You are looking at some other decision of old Supreme Court decision.
No, Supreme Court did not have.
From the color of the book, I could guess it, that you are not looking at that decision. You are not looking at that suo motu PIL 3 of 2020. Nothing. Here is a case where the court has already condoned the delay.
Yes.
But then they placed it, this miscase, maybe by mistake, whatever. But so the order was passed, then I saw it and then again I listed. Then I asked you that if you have any point, even suppose there can be certain cases even directed by the Supreme Court for condonation, but it doesn't fall within those parameters. It cannot be controlled. But for that you are seeking adjournment again and again. The learned counsel for the respondent submits that he may be granted further time to go through the order passed by the order dated 23/9/2021 passed by the Supreme Court in SMWP into bracket C number 3 of 2020. Mr. Mahanti,
My lord.
you also bring copies of that.
Yes, I'll.
Because every time this is being adjourned for nothing.
No, I'll.
The learned AGSL also obtained instruction list on 12/5/2025. I'll call for board speaker.
Item number 6.
Call for board speaker.
Item number 6.
My lord,
Yes.
my lord, I have filed one WPC bearing number 31,427 of 23, which has been disposed of on
Can you hear me? Can you hear me?
My lord,
Can you hear me? Can you hear me?
yes,
ଆପଣ ମୋତେ
yes,
ଶୁଣି
yes, my
ପାରୁଛନ୍ତି?
lord, I hear you. Hear your
So
honor,
you are
my lord, lordship.
you are walking the argument, walking the talk. You are walking the argument or what? Sir, you are doing it in a
My
mobile
lord,
phone. Sir, the mobile phone is not audible, and you are working with the mobile phone, maybe to catch signal or what?
No, my lord. I am in a room, my lord.
Mobile phone.
My lord, I have filed one CMAPL bearing number 861 for a restoration of the WPC.
But that bench is available, Mr. Muswai. The bench is available.
Page.
The bench which passed the order is available.
Let it go to that bench.
এটা আর্জন করে দিও তো লিস্ট অন then 14 same in the same
My lord.
order section
I think.
ଆପଣ କୋର୍ଟ କୁ
My lord,
ଆସନ୍ତୁ
yeah. My lord, ଆଜି ଅଛି ଆଜ୍ଞା 29 ଆଇଟମରେ ପୁଣି ଅଛି ଏଇ କେସଟା ଅଛି। My lord, ଆଜିର 29 ଆଇଟମରେ ଅଛି।
ଡିସମିସal ପରେ କେମିତି ଆସିଲା ଫେରେ
29 କି ରଖାଯାଉ ଆଜ୍ଞା। ଆଜି 29 ଆଜି ଲେଟର 29 ଆଇଟମକୁ ରଖାଯାଉ।
no the Barik, you are not watching the looking at the list and saying this is WPC 31427
31
on 3 is 33687 party name may be same Alekha Chandra
My lord,
but the read petition numbers are different. This will come on 14th. 14th. Mr. Rabindranath Barik for the petitioner. CNFL order ta likhi. It was Sanjeev Singh AGA for the opposite party. List on 14th May 2020. So Barik, ଆପଣଙ୍କୁ ଶୁଭୁଛି ନା ଲେଫ୍ଟ କଣ?
my lord,
14th May. Yes, next.
I don't know, 7.
7, let us pass it over.
Yes, sir.
I'll go through the list for some more time.
Should we fix a time?
So if I complete the list by maybe some another 15 minutes will be left.
Will be.
So let us see how far.
I don't know, 8.
Mr. Jenna.
This is restoration of the WPC number 11238 of 2005, madam. The petitioners, those who are working in Talcher Thermal under OSCB management, my lord, they were taken over by the NTPC and
Restoration order ta kuta restoration.
my lord, we find from unlike that only two annexures, my lord, I'll have a glance, page 8, annexure 1. Annexure 1.
Same APL.
My lord, it has been dismissed for default because 2005 writ petition, Mr. Sarat Kumar Das was appearing and he died. Oh, so
You are saying that there is a surviving cause of action
yes, my lord.
and it is filed within 60 days.
No, my lord. Long.
Hard Mr. Sasibhushan Jena for the petitioner. It is CNAPL. So I 135 or 2025. Mr. Sasibhushan Jena for the petition. Opposite party blank. NTPC, anyone appearing?
Mr. Aditya Das, Mr. Sarkar was also there.
It is submitted by the London Council for the petitioner referring to the order dated 22/9/2023, 22nd September 2023. That The cause of action still survives to be prosecuted by the petitioner. He prays for the petition to be revived. The writ petition to be revived. Mr. Sarkar, you will appear.
Let notice go.
Issue notice along with this order. Requisites for issuance of notice by speed obligated post with 80 be filed within
3 days.
within 3 working days. List after SR, liberty to mention.
Right.
Once please check if SR comes, then we mention it.
Right.
Yes.
Item number 9.
May I please, your lordship?
Yes.
Lordship passed an order on
Mr. Gopinath Mishra for the
Minor.
petitioner.
Minor.
Mr. Item 9, Mr. Sanjeev Singh AG. State so Sanjeev Singh AG for OP number 1. So what you propose, Mr. Mishra? Now address is not there.
Lordship passed an order on 3rd April 2025 to obtain instruction and notice to the opposite party number 4 to appear today. Order dated 3rd April.
Correct.
My lord.
Which paragraph you are referring?
My lord. Paragraph number 4 and 5.
So after that, notice has gone and the report is addressee endorsement left. The you have not see. Are you looking at the list?
No, my lord. This I have.
Cause list achi.
My lord.
Look at the cause list. It shows the endorsement.
Cause list.
Item 9.
My lord.
So what is to be done? The address,
Well,
address left. Notice you have filed.
My lord, probably address may not be that person.
Mr. Learned Counsel for the Hinti Lekhantu. Office note put up by the registry dated 6-5-2025 indicates the following. Quote kar debe. Notice and admission matter so and so. Endorsement left पर्यंत quote ହେଇଗଲା. File ରେ ଅଛି ଦେଖିଦେବେ. The Learned Counsel for the petitioner 6 adjournment to obtain instruction regarding the present correct address. How much time?
1 week.
As wait for list of 15-5-2025 जोड़ाक 14 ହେଇଛି ସେଟାକ 14 ରେ ବହୁତ ଗୁଡେ ମ୍ୟାଟର ଆର୍ଜନ ହେଇଗଲାଣି ଠିକ ଅଛି ଯାହା ହେଇଛି 14 ରେ କୋଟି ହେଇଛି ଲିଷ୍ଟନ କେତେ ଡେଟ୍ ଦେବେ ଆପଣ 13 କରିଦିଅ 13-5 15 ରେ ବି ବହୁତ yes
Diploma.
I don't 10.
14 ରେ ଆଗରୁ ପାଖାପାଖି 40 ଟା ଅଛି yesterday's report is that 14 so don't take ମତେ ଆପଣ ରିମାଇଣ୍ଡ କରିଦେବେ ଯେ 14 ରେ already 40 ଟା 35 ଟା କେତେଟା ହେଇଯାଇଛି ତାହେଲେ ସେଟା ଆଡ ମିସ୍ ଏସ୍ ପଟ୍ଟନାୟକ
My lord,
so what can be done Patnaik? Insufficient.
My lord, we have given the address that has been stated by the opposite party in the MAT case filed by her. My lord, it's the same address.
Could be, but the postal endorsement for insufficient address, there is a problem. देखिए ले फाइल टा सर्विस रिटर्न टा absolutely wrong address. This is not done. You have written so and so at post Sonpur. How can it be?
My lord, the
look
mat
at-
case
you-
page, my lord,
You look at
page,
page 13 of the MAT case.
yes, my lord.
So one has to be somebody like you that so and so Miss Patnaik Katak. Will the letter reach you?
My lord, this is the address given by the opposite
It's a
party.
mistake.
Mat case.
You are not reading actually. That's the problem. Mr. Sahoo is wrongly prompting you. You are not looking at the address. So and so at post Sonpur, district Sonpur. Suppose a letter is sent to Mr. Sahoo. Mr. A Sahoo Katak. Will it reach?
No, my lord, the proper address has not been stated by her in the mat case. We are following
No.
the address.
You are not looking at actually.
My lord,
You have given the address of the girl, the lady, wife of so and so, village post office.
daughter of
So that's it. So
Pani?
this is. Are you sure that without any particulars of simply giving the district or the town, the address will reach?
My lord, may I make a
So
suggestion?
now, with your experience, you should not train the youngster like this.
My lord,
You
may
must
I
look at it.
May I make a suggestion, my lord?
Yes. What you want to say? Be quick.
we may
Just-
submit a copy to the council of the lower court.
No. This is not the way. This is not the way to take notice.
My lord,
You
because
cannot mention that so and so Sonpur. This is not the address to be given. You see, you must understand that this question will be raised subsequently. Suppose any subsequent proceeding, this question is raised that address is that Chinmoy Pani, daughter of so and so at post Sonpur, district Sonpur. What is this? That is how I am asking you, Mr. Sahu. What's your full name?
Abid Sahu, my lord.
Abid.
Yes, my lord.
Abid Sahu at post Katak.
No, my lord, that
Then
original.
why you are denying? Why should you deny?
My lord, liberty
It
may be
says
given.
Patnaik at post Katak, at post town Katak.
My lord, liberty may be given to file an IA.
Even known addresses, the details are given. Then why you are writing you would mark this address. Superintendent, Odisha High Court, TRPC section, Katak, 753302. Why it is given? High Court everyone knows. Chandni Chowk is also mentioned. This is not the way to send it.
my lord, may I take to page 13 annexure?
I've been asking you to look at page 13. You have not been looking. At times, court will be much faster than you. You took almost 5 minutes to look at page 13. When you say that this is the same address given by in the appeal, I looked at that. I was asking, since then I have been asking you that look at page 13. For the petitioner. It's not put up by the registry. It is 6/5/2025 indicates the following. Notice on admission up to orders regarding stay, court content. It is submitted by Learned Counsel, Ms. Patnaik, that the address given is that given in the appeal memo. Address given Address given in this petition is same as that mentioned in the MAT case number 31 of 2024, filed under section 13 capital A to bracket 1A to bracket 1B, pending before section 13 खाली कर दो, detail लिखा है, section 13 of the Hindu Marriage Act, pending before the senior civil judge Sundargarh. Since the address is relied upon by the learned counsel for the petitioner, same is indicated here. It's mentioned in the address, quote, resident of village post office dot Talche, comma, district Hon'Ble, comma, Odisha, at present residing at public post Sonpur, district Sonpur, comma, Odisha. The return postal article, where's the address? The quotation end कर देले, quotation देखिए लेकर use the following address, quote, to Srimati ना लिखे द करने, the following address, quote, at post Sonpur, at post dash Sonpur, comma, district Sonpur, Subarnapur. The suggestion that such address is sufficient to send a postal article on the face of it is not correct. By simply mentioning the district, a person cannot be located. The town and district, a person cannot be located. The petitioner has the obligation to provide the address, present correct address of the opposite party. When do you want
Manner after vacation.
this on? As prayed for list on 36 or in July. 36, 20, 25. The detailed address shall be provided for issuance of notice afresh to the opposite party. You see, when the court is issuing notice, that does the court look at the address? That also you must realize. After it is written answered, Chinmay Pani at post Talche Sonpur, sorry, at post Sonpur, district Sonpur. So at least some semblance of, rationality should be there. Yes, next.
My lord, interim order.
Interim order dated. Can you please tell the date?
Yes, my lord. 7/3/25.
Interim order dated 7/3/2025. Shall continue till the next date of hearing.
I don't know, 11.
11 minutes. This affidavit was sent to me on 5th. I'll take some more time to file a.
Mrs. M. Ponda for the petitioner. 11 minutes. M. Ponda for petitioner. Mr. Nanda, the opposite party. Learned counsel for the opposite party seeks further accommodation to obtain instruction and file affidavit. As paid for, list on.
My lord, I have filed affidavit, reply to their affidavit. I have filed one affidavit, and my lord has directed on the last time to soft copy. I have soft copy on 29th April 2025.
For that he wants to respond and
yes.
say. List on.
My lord.
July.
My lord.
2nd of July.
Reopening week, ma'am.
Reopening है ना अपना करो से 25 ही पड़ेगा 26. Reopening has only 3-4 working days. So
as my lord placed my.
25/6 कर दो.
My lord.
6-20-25. Yes, next.
I don't know 12.
My lord, kindly direct if any reply you will file and soft copies may be soft
Counsel for the opposite party.
before time so that no more adjournment.
That would be filed in the meantime.
Virtual mode.
Petitioner.
I'm on virtual mode, my lord. My lord, I'm on virtual mode, my lord.
Yes, Mr. Misra, there is actually a hearing matter has been, passed over. So I cannot take up any other further hearing matters unless I reach that.
And
So
my,
I'm just going through the list.
this is the matter relating to 2011.
Correct,
Therefore,
correct.
I humbly pray before the Lordship, fix a date.
After vacation.
Naturally, last week only
There is no date actually left before vacation. Mr. Kari Prasanna Misra, Senior Counsel, instructed by Mr. Admiralty Misra. Mr. Admiralty Misra for the petitioner. Mr. Manoj Kumar Patti for the opposite party, all the opposite parties.
Well,
Senior Panel Counsel.
Well,
Mr. M.K. Patti, Senior Panel Counsel for the opposite parties. On consent list or 8-7-20-25.
7 means, my lord, in July.
ଆପଣଙ୍କର third week of reopening.
Obligement.
Third week ହେଲେ ହବ 8 ତାରିଖ ହବ 2-7
My lord.
first to second third 2-7. Yes. Readings are complete, Mr. Misra. Readings are complete.
readings are complete.
Yes, next.
I think second mentioned.
Correct. So the order that you put.
I don't know 13.
Because
Naik on behalf of A.K. Pandey for the petitioner, Mr. S.P. Ponda for the opposite party. On consent list on 8 July 2025. Yes.
I don't 16.
14.
14 ଆପଣ serial ଡାକନ୍ତୁ ଆପଣ miss କରୁଛନ୍ତି.
I don't
All the matters have to be called serially so that ଆପଣ difficult ବୁଝୁଛନ୍ତି. Dr. Misra was not there. ଆପଣ ତାଙ୍କ matter ଛାଡ଼ିଦେଲେଣି 16 ଡାକିଲେ. So that is the reason the matters are not taken up at random. Serial ଡାକନ୍ତୁ. Item 14, Dr. B.K. Misra for the petitioner. Dr. Misra, they say that they will file Wakalatnama after Mr. Ratha has passed away. So they will be they will be replacing
Yes,
Ms. M. Jenna on behalf of Pami Ratha, Senior Counsel for the opposite party.
My lord, one more.
It is submitted that after unfortunate demise of the Learned Senior Counsel, who was appearing for the opposite parties, Ms. Pami Ratha, Senior Counsel, has instructions to appear. Pami Ratha instructed by Ms. M. Jana, Senior Counsel. Ms. M. Jana has instructions to appear. She shall file her appearance memo by the next date. Yes, Dr. Misra.
Well, at last occasion, I had undertaken to amend the cost title because the company had changed. IA is at flag M, your lordship. May kindly pass.
They mention kari padele ei to problem. They are not waiting for the other council to say something or.
Lordship, may kindly allow that.
Now it has become OMC.
Well.
It election appearance elected. Press for accommodation. Dr. Misra, Learned Counsel appearing for the petitioner submits that IA kete 957
2955.
Sorry,
2955 that flag M.
Just kindly speak to the microphone.
2955
2025 has been filed for amendment of the cost title in view of the opposite party being amalgamated now merged. Opposite party company having merged with another company.
Odisha Mining Corporation.
Odisha Mining Corporation
Limited.
The amendment as prayed for, copy of the petition has been served.
No, I've got it once. This is allowed, I will serve it.
The
I'll serve it, I'll serve.
copy of the petition be served on Miss M. Jenna. She might be here.
I'll find it.
So,
I'll find it.
M. Jenna, the Lord Instructing Counsel of Miss Ratha, Senior Counsel. Senior Counsel, Miss Ratha.
May I submit one for the courts?
Yes.
Courts copy.
No, since it is paperless,
Okay, I'll file.
file କରିଛନ୍ତି ନା କରିବେ?
I'll file kar dijiye. IE is at flag M.
Correct. Hey, ଆପଣ ଏବେ consolidated cost.
Once that is approved, then I'll file that.
Okay, the nahanti. So can you serve and so can you make a phone call to them?
I don't know.
You don't have.
My lord,
I understand. I'm putting you into difficulty.
my lord, your lordship.
अच्छा ठीक ଅଛି. Since on लिखिए. It is submitted by the Lord Counsel for the petitioner that since the amendment is necessary for effective adjudication, amendment is allowed. Consolidated cost title shall be filed. How much time?
I have got it, your lordship.
During shall be filed within 2 working days in the registry.
Serving copy upon that.
Copy of the consolidated cost title shall be served on the learned counsel, Miss Jenna. Instructing counsel, Miss Jenna.
And pleadings are complete.
Since the learned counsel, Miss Senior Counsel, Miss P. Ratha has already appeared. Her name shall be mentioned in the cause list as well as the case brief. Name of the counsel who were appearing earlier shall be deleted. As prayed for by the learned, prayed for on behalf of the learned senior counsel, list on 3/7/25. The learned the instructing counsel appeared and took adjournment. So in fact, this I have been asking that whenever there is an orders matter, this is of course it's after notice matter, but since their substitution is there, you file it. After what line add kar diyo, to after filing of the consolidated cost title, the scanned copy be updated. State petition the
again.
State.
Not chairman, managing director.
Only chairman.
No, mining corporation.
Yes, next.
Item 15.
15. Miss M. Jenna, Learned Instructing Counsel on behalf of Mrs. Pamiratha, Senior Counsel. Mr. S. Misra on behalf of S. Patnaik for the opposite party. Somalin Patnaik. S. Patnaik confusion was Somalin Patnaik. Somalin Patnaik for the opposite party. On consent list on 9/7/25.
Item 16.
15. Sorry, 15 gala 16. Yes.
My lord. And as per your lordship's order, 1/5/2025, the representation filed for the DTM is brought on record, my lord. A annexure 80. So lordship's order. So they have been, my lord, in a
Mr. Tripathi option.
Yes, ma'am.
Mr. S.B. Mohanty for the file करछन्ती
ना फाइल कर दीजिए
flag
मागे
कितने flag रे अच्छी
फ्लैग अच्छी से
कितने ना लास्ट जोड़ा flag M flag M Mr. Subhranshu Bhushan Mohanty, S.B. Mohanty for the petitioner Mr. A.K. Behra.
Yes, for OSRTC.
For the opposite party. State is a party here.
My lord.
State party achanti.
State partner. MD or DTM.
Achha. For the AK Behra for the opposite parties. AK Behra along
Pardon,
with
my lord.
Tripathi.
Yes, ma'am.
Mr. A Tripathi.
Amitabh Tripathi, ma'am.
for the opposite party. Sorry.
Amitav Tripathi, manager.
ଆଚ୍ଛା ହଉ ଠିକ ଅଛି ଆପଣଙ୍କର ପାୱାର ଅଛି ନା
Power ଅଛି.
ଅମିତାଭ ତ୍ରିପାଠୀ ଦେଲେ ଆଗ ଲେଖନ୍ତୁ ଅମିତାଭ ତ୍ରିପାଠୀ
Yes, yes.
along with Mr. AK Behra for the opposite party. The learned counsel for the paragori ଲେଖନ୍ତୁ the hard learned counsel for the petitioner. The learned counsel refers to the affidavit dated 3/5/2025 filed by the petitioner including representation dated 24/4/2025 addressed to the OP number 2. Copy देनांती ଏବେ ଦେଇଦିଅନ୍ତୁ OP number 2 district transport manager
DTM cutoff.
district transport manager full form.
Yes.
This habit of writing short form DTM, OTM, District Transport Manager, Odisha State Road Transport Corporation, Cuttack. Stop. In view of the in view, no order ta quote kar diyo. On 1/5/2025, upon hearing the learned counsel for the parties, the following order was passed. It is observed that the opposite party authority shall take a sympathetic and pragmatic view, considering the age and ailments of the petitioner, and dispose of the representation within a reasonable time. The writ petition stands disposed of.
Time.
ସେ ତାଙ୍କ ଆଡୁ ଭଲ କାମ କରୁଛନ୍ତି ଆପଣ କରିବେନି ଆସନ୍ତୁ. These things create a mistrust actually. When they on their own they are extending a helping hand, why should you doubt them? It is ଗୋଟେ ଲେଖି ଦିଅନ୍ତୁ Mr. Behra, Mr. Tripathi for the opposite parties submits that the authorities shall act promptly to consider and dispose of the writ petition. ତାପରେ ସେଟା dispose of କରିଦେବେ. Yes, next.
Item number 17.
17, Mr. AK Sharma. Petition WPC 14466 of 2015.
In case I am appearing for the petitioner, my
AK Sharma for the petitioner.
not file count for me.
In view of the counter filed in the first case.
Mr. Swai, you will be appearing for state also.
No, not for state. Not for the state. I'm for KDA, Cuttack Development Authority.
Mahanti.
Mr. Behra.
So
Mr.
Behra
Prabhu
was
Prasanna Behra, Additional Standing Counsel. Achha, where is Prabhu today? All are looking for Prabhu.
so NCLT matter ଗୁଡାକ କରିବାକୁ
ଆଚ୍ଛା, Prabhu has gone to NCLT.
ଏପଟ ସେପଟ ଖାଲି ଦୌଡୁଛି ଏପଟ।
Mr. Prabhu Prasanna Behra, Additional Standing Counsel for OP1. Mr. Sandeep Swain for opposite parties 2, 3 and 4.
2 and 3.
Chairman is also a party. Chairman, Vice Chairman, Secretary, all have been made party.
For all.
Mr. Jenna has adjourned it to 3rd July.
Second matter.
Mr. Sharma, he was not there.
So far as my learned senior has stated that.
First case in view of the counter filed in the second case or in view of second case, first case has rendered infructuous.
Your Lordship recorded that.
Happy.
That is to dismiss.
Mr. Sharma is why you are so happy today.
So far as second case
It is very difficult to convince you. It is submitted. It is stated and submitted by the learned counsel appearing for the two opposite parties 2, 3 and 4 that in view of the counter record ଦେଇପାରିବେ क्या बोले?
second case
ସେଟା ତ dispose of ହେଇଯିବ ନା ତ ଆପଣ how
ସେ question ନିଜେ that is one some.
serve a copy, file a copy along with a memo. Let it be on record.
Let it come on 3rd July, 3rd July.
I would file for them.
I would.
I would call for
Yes,
an
yes.
affidavit করে পড়ি মতে।
Call it. And submitted for this. Noted by Mr. Swine, noted counsel for opposite parties 3 and 4. That in view of the counter affidavit dated date
18/3/2025.
18/3/2025 filed in the connected WPC 12497 of 2020. The writ petition doesn't require any further adjudication. The learned counsel, Mr. Sharma, appearing for the petitioner, submits that the submissions may be recorded. The submissions are noted. Submissions are noted. The learned counsel for the opposite parties 2, 3, and 4 is requested to serve copy of the counter affidavit on the file copy of the counter affidavit along with a memo to be kept on record in the writ petition. Copy thereof shall be served on Mr. Sharma.
By tomorrow.
Within 3 days, 3 working days. Within 3 working days. 3 साथ राशि बताओ ना dispose कर दी.
না ডিসপোজ করে দাও সে আসিয়াକୁ রাজি ন করে ମୁଁ କାଇଁ ଆସିବି।
ठीक है जी ताले during course of the day take कर दियो.
ଆଜ୍ଞା।
Shall be served during course of the day. The same shall be taken on record. The writ petition stands disposed of.
Right.
After Lekontu, if you have any difficulty, you can take help of court master. He will get you copy.
ନା
Yes.
ଅଛି ମୋ ପାଖରେ
Or
ଅଛି।
Mr. Sharma. Second matter, Mr. Sosibhushan Jenna for the petitioner. Mr. Prabhu, additional standing counsel. Prabhu Prasanna Behra, additional standing counsel for the UP number 1. Mr. Sanjeev Swain is counsel for OP number
213.
213. Mr. The learned counsel for the petitioner submits that he has received copy of the counter filed by the.
You also file rejoinder.
He has received copy of the counter filed on behalf of the opposite parties 2 and 3 and seeks accommodation to file rejoinder as paid for list on 3rd July 2025. Copy of the rejoinder shall be accepted on the next date upon copy thereof being served on the learned counsel for the opposite parties 2 and 3. Yes.
I don't know, 18.
My lord, here,
Sir Ratha, these old matters.
item 18, my lord.
18, 16 I was not appearing, but in old matters I was appearing for Valmi.
Your ship was not appearing for one.
Then 16 I'm sure. Is there any connected matter which dates back to 2005? Like
I remember, my lord, with my little experience, I was there in against Valmi from 90 something.
Yes.
I've never seen that your lordship was also arguing the
after
matter.
2005, definitely. These are 2016 matters.
SK Naik was there. Thereafter,
Yes.
many other people are there.
Yes, yes.
Your lordship was not assigned to it, I believe.
For some time, I was appearing along with Mr. SK Naik till 2004. That way. Then Mr. Rao was also appearing.
Yes.
Now Mr. Mahapatra.
I know. Mahapatra has come very recently.
Yes,
Now,
yes.
yearly. Rao continued for some time.
Yes.
Prior to that, Mr. Rao was continuing for quite a long period. I was facing both all these people, but I have never seen that your lordship was a lawyer for Valmi.
Along with yes, Mr. Ratha. This is a hearing matter.
Yes, madam.
I have already passed over a hearing matter, item 7. So it has to be adjourned because it can't be taken up the no dates.
That means today no hearing matter will be taken up.
No other hearing matter, there is
Only
a suit.
only suit
Admiralty
to be taken. That
Yes.
Admiralty suit will be taken.
Yes, yes.
Then I can't say anything because once it's
After vacation, can you suggest a date?
sir, it's a congregate difficulty Ruchi. If can be before vacation. Because the law has already been settled by the external court, settled by the apex court. I don't think if the matter can be heard within half an hour or 1 hour, everything will be settled. Nobody is going to change anything.
Yes, what do you say, Mr. Barik?
My lord, as per my lordship, on this matter.
Mr. M.R. Pradhan or,
My lord.
or J. Barik?
MR Pradhan, my lord.
M.R. Pradhan. Mr. Pradhan, suggest a date before the senior is requesting for a date before vacation.
My lord, last week any date, my lord.
Last week,
I thought sorry,
last week, 1 week. Last week, last week,
This is the last week, my lord. So, 13th or 14th any date, my lord.
Nine, before vacation, I'm telling you, the resolution.
Very difficult, Mr. 14th. I was informed yesterday that about 40 matters has been adjourned on 14th.
Yes, my lord. Your lordship
Should be taken up, my lord. If my lord senior is permitting, then my lord.
on 14th.
On we commencing, my lord, we commencing vacation because
23rd.
My lord may have it on 14th. My lord shall fix a date. Because he is not able to decide.
So, Mr. Ratha, will it be 23rd of June, reopening?
23rd of the June.
Yes.
I can't have any choice. Yes, Judge.
Mr. Jayanta Ratha, Senior Counsel, J.K. Ratha, Senior Counsel.
My lord,
instructed by
without
team-
reckoning, my lord shall fix of that way. So that he agreed for.
No, I have to say that he has suggested it. Yes, because he is unable to decide. Mr. Instructed by Mr. D.N. Ratha for the petitioner. Past matter 4744. Mr. M.R. Pradhan, instructing counsel on behalf of Dayananda Mahapatra, Senior Advocate. It is submitted by the Learned Senior Counsel, Mr. Ratha, that the matter is pending since long. The issues have already been finally decided by the coordinate bench and also
And also by the apex court.
By the apex court. He requests for early hearing. Product Counsel, Mr. Pradhan, seeks accommodation on behalf of his learned senior on consent list on 23/6/2025 liberty to mention for our listing before the assignment.
published.
Your cabinet data, sir.
23/6.
I don't know, 19.
That would be the 5th day of reopening.
Item 19, Your Lordship, I'm appearing for the petitioners.
Yes.
This is also a matter where the matter is ready for hearing. All the pleadings have been completed. And we have also filed our written submissions. Your Lordship.
So since this bench will be hearing for the first time, I will first actually hear you.
Your Lordship.
So
Lordship,
you can base your submissions referring to the written submissions.
Lordship.
Mr. T.K. Patnaik for the petitioner.
My learned son, Mr. Nanda, is there for PPD.
Mr. P.K. Nanda,
No,
senior counsel, or senior panel counsel.
Normally, I am appearing with the Paradip purpose.
I am appearing for OP number 1, my lord, Dilip Kumar Sahu.
Mr. Dilip Kumar Sahu.
I am
CGC.
CGC.
CGC for OP
OP
number
number 1.
Mr. P.K. Nanda for OP number
213.
213. Who is appearing for dredging corporation?
No one, Your Lordship, that's a pro forma party. We are not pressing any relief against that.
Non-exit. It is submitted by the Learned Counsel for the petitioner that the matter is ready for hearing. Since no relief is sought for against OP number 4, appearance of OP would not affect further hearing of the matter. On consent list after vacation, what a date called?
24th June, your lordship.
Consent list on 26/6/25. So Nanda, you have any difficulty?
No. Obliged.
I don't know, 20.
Yes.
The pleadings are complete, if your lordship.
So it has to because already I have almost consumed the fast track. So, Mr. You don't have power, Mr. Bishwal.
On behalf of Mr. Samal, your lordship, SK Samal.
Mr. J. Bishwal on behalf of Mr. S.K. Samal for the petitioner, Mr. Banshidhar Bagh for the
Copy number 2.
senior counsel instructed by Mr. Sahoo.
Sahoo?
Mr. G.R. Sahoo for the OP number 2. State, who is appearing? Item 20. Mr. Rajdeep Pradhan, additional standing counsel for the OP number 1. But date suggest karantu.
Before vacation, my lord, anytime. Or, my lord, let it be after vacation, but my submission is only, your lordship on the last occasion, almost.
I have some difficulty in forgetting. So
No, my lord, I am not on that. Fact remains, since 2017, publication or result of recruitment process is stayed. So only my submission that may be modified. Any appointment is subject to result of the writ petition, and in the appointment it will be written. That
is what you say. Opposite that.
It be after vacation, your lordship.
That almost. In fact, I have observed that. I have observed that clearly in that order also. In fact, that day's hearing is reflected.
only to place whether there is finance
21st
concern.
April, it runs to 5 pages also. So everything has been recorded.
My lord,
On
yes.
consent list on. But date suggest karantu. Apana ki Mr. Bagh kohon, senior kohon.
Again, 18/6 ରୁ 17/6 ଖୋଲୁଛି 18/6
से फास्ट वीक रे रखंतु 4 दिन छाड़ दियंतु ये 19/6 कर दो ठीक है
ଆଜ୍ଞା 19/6 ରୁ ଆଜ୍ଞା my lord
list on 19/6
only prayer my lord in the fresh heading my lord. Otherwise it will not reach.
Liberty to mention apana mention karo liberty to mention.
That is interim order to continue.
Interim order dated 13/10/2017 shall continue till the next date. Commission the record karo to the senior counsel, the learned counsel. Senior counsel appearing for the opposite party number 2 submits that since 2017 the interim order is continuing. After conducting the examination, the result is yet to be published. The order may be modified to the extent that the amendments be made subject to result of the writ petition and further orders that would be passed by the court. And let's stop and no stop. Such indications shall also be made in writing in the appointment order itself. Appointing order, no? Appointment order.
Yes.
Appointment order. The learned counsel for the petitioner, Mr. Bishwal, seeks adjournment. Yes. This is item 20.
20 my lord.
First matter है 20871.
धीरे जाकर समान आ गया.
Second लिखी थी in view of the order passed in WPC number 20871 of 17. List on
19/6 again Fred sir admission list.
देखो जेटा
ना reach करियो ना पढ़ियो नि नहले.
mention करो.
आगे आगे.
So that is how I have recorded your submission also.
आगे.
That would
The interim order to continue, your lordship.
My 10 I have said. Or submission टा पछुको पड़ेला सेटा submission ऊपर को जिबो.
I'm grateful.
Yes.
I don't know 21.
21 in hand.
May I please, your lords? Hello, on behalf of Mr. Sahoo, my lord.
Behalf of Mr. Sahoo, you be there, Mr. Mutunjay.
My lord?
21, you are appearing.
My lord.
For whom?
Personal, my lord.
So Gyanendra Chandra Soy likha hai.
On behalf of Mr. Sahoo, my lord.
NK Sahu.
Aye.
Mr. A. Pagal for on behalf of NK Sahu for the petitioner. Anyone for the opposite party? Opposite party, none. List of. As prayed for by Lord Counsel for the petitioner, list of. July, like June, keep it on.
June
After
bhitor.
vacation, English for you.
My lord, June last aadu
List on 36.
Aye.
36, 20, 25.
Aye. Bless.
Mr. Ratnas. Yes, Mr. Ratnas.
Sir,
Same difficulty. Yes, yes. 22. Same difficulty.
Confused.
Say,
Sir,
hearing matters.
Sir, I know the mind of the court now. So, এইটাকে রকম স্যার 19 তার রকম
19 Mr. Jayanta Ratna.
19 June মাস ছুটি পড়ে
by Mr. D.N. Ratna.
Sir, I have no
petitioner.
You can't have an objection, sir.
Senior advocate is saying, my lord, what objection can I have? I am appearing for Central Bank of India, my lord, in two matters.
Mr. You have decided to be after me or what? I'm dictating the order. So listen. Mr. You are writing SK Misra or S Misra?
S. Misra, my lord.
So S Misra for the opposite party.
Central Bank of India.
It is submitted by the senior counsel that the pleadings are complete and matter to be heard on consent list on 19.
Again.
19-25.
Admiralty Service should be said. Admiralty case
I am also appearing in few matters.
There are 4 matters. Mr. Sarangi is appearing in 2. I am appearing in 2.
Sir, if you don't matter, so that they can get their bills through.
You don't bother about our bills. We don't get bills.
Mr. Sodangi will not allow that.
I am obliged to your lordship for that remark.
I will share.
First matter is Misra. First matter is Mr. Sodangi.
Sir,
first matter is list of it.
first, third. First and third.
बाकी दीटा आ गया मोर
our last sir, first, third and last.
तो मैं तीन क्या से दी जाए
आ गया
23081 23082
ना bro आ गया अच्छी already
ना bro sir
the name appears. The name
आ
appears.
गया names appearing.
Yes.
Admiralty
लिखा है कि SK Sodangi लिखा है. Mr. SK Sodangi, senior counsel, instructed by Mr. SK Sodangi also.
हाँ sir.
Yes.
I don't know, 23.
23. 23.
I don't know, 23.
Petitioner none. Mr. DSGI. Party.
My lord, in this
DSGI for the opposite party. Yes, Mr. Party.
Yes,
It has to go after vacation.
my lord, but I am requesting my learned friend. They might have given the copy to our previous counsel. Can I give the copy of this and then I will tell?
No one is there to. I mean, no.
Then I'll search who is the counsel. Then I'll pursue it. Only my submission may be noted and judicial order may be reflected that a copy of this may be served.
When they appeared last also, let me check.
Yes.
No one is appearing. None appears for the petitioner when the matter. Upon likhile item 23 election data. None petitioner none. Mr. PK Padhe DSGI along with Mr. Samantarai.
Yes, S. Samantarai.
S. Samantarai CGC for OP1. OP2 to 6 none. None appears for the petitioner when the matter is called. None had appeared. When the last on the last occasion when the matter was taken up. Stop. The registry has also not been able to contact the learned counsel for the petitioner in absence of the details like mobile number. On 1/5/2025, following order was passed. Para 2 to 4. 1 to 5 4. Apparently, the petitioner is not interested to prosecute the matter, as no one is appearing. Despite the order dated 1/5/2025, that the matter shall be proceeded with, in absence of the learned counsel for the petitioner. The writ petition is disposed of for non-prosecution, granting liberty to revive the same within 60 days for any surviving cause of action. Yes.
Item 24.
Yes, Mr. Chairman.
Here, in view of the amalgamation of the two rural bank, I may have to change the cost title. I will file an amendment
Mr. P.C.
petition.
Chinchani for the
Let it be.
petitioner, Mr. K.K. Jena for
I'm the petitioner.
I'm for the opposite party bank matters.
For the opposite party. He submitted that the opposite party, Utkala Gramin Bank, has been merged or what?
Yes, two rural bank have been merged. It has been named as Orissa
Gramin Bank.
I have to change
Gramin Bank has merged with
both Odisha Gramin Bank and Utkal Gramin Bank
merged
in single.
Odisha Gramin Bank, Odisha Gramin Bank to form a new entity.
Now presently named as Odisha Gramin Bank.
Odisha Gramin Bank. The learned counsel for the petitioner seeks leave to amend the cost title.
Let it come on 15th, my lord.
Amended cost title. You have to score through two pages.
Again?
Suppose you want to write it out in the cost title.
Yes.
All the three opposite parties have to be scored through and again entered. So you file.
Yes, I have to file an amendment petition. Or if you
allowed.
Huh?
I'm allowing you.
Yes, my lord.
Cost title. Prayer is allowed. The amended cost title, pleading the new entity, Odisha Gramin Bank.
Gramin Bank.
Odisha Gramin Bank shall be brought on record as opposite party. The learned counsel for opposite party submits that he has also instructions to appear on behalf of the Odisha.
Asini.
He can obtain fresh wakalatnama.
He shall also obtain instruction and file wakalatnama. List on
15th, I am praying for 15th, my lord, because there is only.
Possible, sir. Not possible.
My lord,
already actually somehow this, because of hearing the.
Let it come after vacation so that I can.
So that also he can get, suppose that day also you file amendment. He says that till now he doesn't have instructions to appear. Will it not be harsh on him that he was appearing now? It is a merged entity, new entity. So you must give him that also.
That is a technical requirement, but the core issue.
The core issue is something different.
Core issue is.
Wakalatnama has to be by the duly authorized whoever is appearing. Otherwise, because that is in your interest. You suppose the order is passed in your favor, they will simply say that we are never represented in the court.
No, that I understand.
List on 36.
Earlier, he is dismissed.
The learned counsel for the appearing parties shall do the next.
Earlier,
Sir, that is the 36 only the in the 9th day of reopening.
Again.
So Monday. 36 is the Monday.
Yes, ma'am.
I don't know, 25.
Yes.
Day after tomorrow, it may not be possible.
Day after tomorrow, not possible.
It's a long matter, it will take some time after vacations.
Before vacation.
Before vacation, you see, there are only 4 dates, 5 dates. And there is other benches also. Apart from my regular bench, there will be other benches. 16 is not to be counted as a working day. Usually that's the
Short matters for university.
reopening रे आसु. Reopening रे आसु. Simply, if you, I mean, if you are satisfied, I'll simply give a date on say 12 or 13. ठीक है.
That will possible, it will take some time.
Obviously, I understand. That's possible. Ms. Archana Mahanti, Mrs. Archana Mahanti for the petitioner, Mr. 25 there for state. Mr. Devraj Mahanti, AGA for OP number 1. Mr. Sanjeev Swai, standing counsel for staff selection.
OP number 5.
4 and 5.
Yes. 5.
Appearance I would watch. Mr. Devraj Mahanti for OP 1, TOP 4. Mr. Sanjeev Swai, standing counsel for OP 5. The pleadings are complete. Matter is to be heard. List on. What 15 କହୁଛନ୍ତି? ଏବେ କହିଲେ? ଦେଖନ୍ତୁ list on 15 ପାଇଁ.
Before vacation, happen.
Definitely, she will be satisfied if it is listed. So that is I am only that much for another day I am listing. It's not possible, Miss Mark. List on 26 कर दियो. Reopening immediately about 26th of June. 26th of June.
26th.
Yes, call the list.
I don't know, 26.
Mr. Niranjan Biswal. N. Biswal for the petitioner. Mr. 26, Mr. Swai or Mr. Mahan?
No, not check mine.
Mr. Sethi, Ansuman Sethi, additional standing counsel for the opposite party. On consent, list on 7/7/25. तीनटा मैटर अछि. Same appearance. Mr. Sethi, you are appearing in all 3 matters?
Yes. I don't know, 27.
Twenty-seven to 40. 27 I can take up your matter.
My lord, as per the last order, your lordship has directed me to respond to the affidavit of the state.
Right.
I have already contacted the client.
Okay.
He needs some further time to
Mr.
respond.
P. Das, you are there in 27.
Yes, ma'am.
Standing Ben Prakash Ponda.
Yes, ma'am.
Mr. P. Das for the petitioner. 27, Mr. Rajdeep Pradhan. Mr. Rajdeep Pradhan, additional standing counsel. For OP 6 and 7. Mr. B.P. Ponda, CGC अपना.
No matter.
Senior panel counsel.
No.
Or counsel.
Counsel for
Achha,
answer.
Mr. B.P. Ponda for OP number 8 and 9. Likhuntu, the learned counsel for the petitioner submits that in terms of the order dated 23/4/25, he has sought for instruction from the petitioners, which is yet to be received. He seeks further accommodation. As prayed for, list on. Yes, Mr. Ponda, suggested date.
Lord, after vacation, any day, I agree, my lord.
Mr. 2/7/20
My lord.
2nd of July.
My lord. So before, my lord, because the mining has been stopped, my lord, because that's the only difficulty, my lord.
ମୁଁ ଆପଣଙ୍କୁ ବେଶୀ ଦିନ ଆଗକୁ ଦେଇନି. This is only the 3rd week of reopening. It is a matter of only 2-3 days. List on 30/6. Same week. Can you see the calendar from that distance?
Yes, ma'am.
Yes. July se tar nahi. July achi.
July 2 is the, my lord, Wednesday.
So I gave you the third week working week of after reopening.
Yes, ma'am. 2nd July, my lord.
2nd July कर दो.
Interim order maybe.
Interim order dated 6/1/2021 shall continue till the next date of hearing. So the rest of the matters will be left over and added to the list. Item 28 to 40. Anyone seeking any adjournment can mention. Suppose any adjournments you can mention.
Tomorrow.
Item 35, it is
So then please let us go by page wise.
Item 28.
Now page 8. Page 8.
Item 28, your lordship.
28.
28.
You are Mr. Parsuram Panda.
My lord.
For the petitioner. Tapare opposite party.
Is the present.
ଆପଣଙ୍କ ନାଁଟା?
Monalisha Mohan.
Adjournment ଚାହୁଁନାହାନ୍ତି ଆଜ୍ଞା
It's your power. P. Panda for 28 ଲେଖ. P. Panda
behalf
for
of
petitioner. A. Mohanty for the opposite party. On consent list terms. Give a date after vacation.
Next week था आज्ञा. Next week.
ठीक है. Kindly speak to the microphone.
Next week again.
Next week नहीं पड़ेगा.
Only transfer applications pending for 2023, your lordships.
So is it that I have halted the proceedings since
No,
23? So
no.
I have only a month, 1 month.
Your lordships.
Rather, you should settle it and agree for a place of prosecution. Yes, Miss Mohanty, ଆପଣ କଣ କହୁଛନ୍ତି? Will it be taken up next week?
Next week, yes, ma'am.
On consent list on 14/5.
Interim order may be continued.
Interim order to continue. Then it's like consent list on 13/5. Not 14/5. 14/5, too many matters have been listed. 13/5. But after notice matters cannot be taken up. That's the difficulty. How many matters have it come? Then item 29 to 35.
Item 32, your lordship.
Yes.
The matter may be taken after vacation, your lordship.
You are for?
Petitioner, your lordship.
ଆପଣଙ୍କ ନାଁଟା?
Sumanta Bhuiya.
Mr. S. Bhuiya. Item 32, Mr. S. Bhuiya for the petitioner, opposite party blank. List as prayed for list on DC6.
Item 35, my lord. Pleadings are completed.
Your lordship, interim order is to be continued, your lordship.
Interim order to continue. 32 interim order to continue.
Oblige, your lordship.
35 pleadings are completed, my lord.
Then
35 pleadings are completed, my lord.
No, you agree. 35 it will go for if you want any specific date you mention.
छुट्टी पर
After vacation.
छुट्टी पर गोटे डेट हो सेदिन शेयरिंग
Mr. Ranjan Kumar Bishwan, petitioner 35. 35 who is appearing for state?
State only.
Who is the counsel for state in 35? Apana. Mr. Anshuman Sethi, ASC for the opposite party. On consent list on एक के साथ है
एक साथ ये लॉर्डशिप
yes next call करो तो 36 seconds.
I don't 36. There's item
Mr.
number
SS, sorry.
Item number 39, my lords.
39.
39.
Just a second. Item page 9, there are other mentions already made actually. So you will not be able to just wait. No, he is coming for a fast day, so he has some difficulty.
My apologies, man. I was.
So he is also not acquainted with my style of. Item 36, Mr. S.S. Ponda for the 36, Mr. Das, you are appearing?
No, no.
39. Just kindly wait. There will be only one or two matters mentioned for this. Mr. S.S. Ponda for the petitioner, opposite party blank. As prayed for by the Lord Counsel for the petitioner, list on 8/7/25. Entry border check कर देंगे. Then item 37.
I don't have withdrawal memos there.
Mr. Karunakar K. Gaya for the petitioner, opposite party blank. The Lord Counsel for the petitioner files memo of date indicating that the petitioner doesn't want to prosecute the matter. Stop. The memo is taken on record. The petition stands disposed of. If you have a document, what a staff pariwale. Court staff mariki record re bandi. The record the best.
I don't 38.
38 add kar debe list. Two दिन को add कर दे. 39 Mr. Das, Mr.
My lords, in this case, my lord, as per your lordship's last order, my lord, we have served a copy on IDCO, my lords. He's appearing, my lords.
Okay. You have brought implemented
We
as
have,
a party.
yes, my lord, costs have been filed, my lords.
Mr. S.K. Das, senior counsel, instructed by Mr. A. Patnaik for the petitioner. 39 upon good habit. Be careful upon 39. Mr. A. Patnaik for the petitioner. Is submitted by the
Pardon to mention.
just go sorry.
In this case, my lord.
Go second. Let me get the brief. I have not reached 39 actually. The Patnaik order dated 1st of May.
1st of May. Yes, ma'am.
The Learned Council for
Order number 16.
The Learned Senior Council refers to the order dated 1/5/2025 to submit that IDCO has been included as a party, as a
Pardon, my lord.
is Dora, you inform the Learned Senior? Yes.
My lord, item
Pardon,
number
my lord.
29.
Item 39. Item 39.
29.
Second item. I am for the opposite respondent.
39 next matter LA 17 देखो
Yes, ma'am.
Mr. A. Sahoo.
Again.
Mr. A. Sahoo.
1A to 1E. Respondent.
1A to 1B.
Again.
Yes. 38.
My lords.
Yes.
The appearance may be noted.
Yes.
My appearance may be noted, my
No,
lords.
definite. It was taken up kind of a mention.
Lordship is posting it to 2nd week of July.
No, I have simply 38. It was to come up maybe tomorrow like that. Today taken up. 38. You are there for the petitioners.
I'm for the all in all the
Subir Palit, Asina.
opposite parties counter obviously.
Staff are little bit overburdened. One is on leave, so they are yet to come. When yesterday's evening work, they are still continuing. Just give give some accommodation. Can you wait for 5 minutes?
Again.
Please.
My lord, item number 29. My lord, item number 29.
Yes.
I am for the respondent, my lord.
So,
my lord,
you see, it is not possible to take up any hearing matter. So one matter is heard, so the next matter is unlikely to reach. So 29, when do you want?
Tomorrow, my lord.
Tomorrow not possible. You cannot travel also. All the air routes will be closed.
My lord, Monday, 12th May.
After vacation, Mr. Barik.
My lord, ଗାଡ଼ିଟା ନଷ୍ଟ ହେବାକୁ ବସିଲାଣି my lord. ଗାଡ଼ିଟା 4-5 ବର୍ଷ ନଷ୍ଟ ହେବାକୁ ବସିଲାଣି my lord. ସେଇ ଯୋଗୁଁ କହୁଥିଲି.
So what? Since 23 something is pending, how can I say that?
Before vacation, my lord.
Item 29.
Before vacation.
29 lekhantu. Who is 29 for the state appellants? A petitioner?
Petitioner?
Total blank chhad deithan. For an order likhibe. AC oblique PG asibe. Mr. Rabindranath Barik. For the opposite party. Lord Counsel, Mr. Barik, being present at the virtual court, High Court of Orissa, Noagar, addresses arguments. He requests for listing on 12 कर दियो 12/5/2025 list on 12/5
Oblige, my lord.
My lord, item number 30.
30.
Yes, ma'am.
Yes.
To file an amendment petition, kindly 2 weeks time.
30.
I am for the
S. Rana.
my lord, I am for the opposite party 6. Last
Can you speak to the microphone? Microphone.
Last time, my lord senior has taken time for amendment, my lord.
Correct.
But in the what happened, my lord, the advertisement taken place for the women SSG group, selection of women SSG group for civil supply department for supply of food materials. They have selected for last 2 years and approved for last 1.5 years. And in the meantime, they have made an agreement with a...
Sir, unless the amendment is filed, copy is served on you.
My lord, the petitioner is not a party to that advertisement.
Sir, you are still mixing up. A pending read petition pending since 2023. Should I have to address this?
I am not objecting for amendment, but before vacation, because the women SSG group.
How can it be? How can it be before vacation every matter is to be accommodated? My court master tells me that on certain dates I have already adjourned about 35 matters.
Sir, the
matter is filed since 2023. We are in 2025 May. Certainly it becomes urgent.
Time nochandi je semane masku 3000 taka ghar bada dochandi.
Time nabata is a part of the legal process and strategy also.
Again. So selection already ହେଇଛନ୍ତି କିନ୍ତୁ ଯେହେତୁ there is no such stay.
Sir, when the interim order was passed in 2023?
Sir, collector
my collector kontar answer. Interim order was passed way back in 2023.
No, interim order nahi.
Then why you are worried? I don't understand.
No, I am for the respondent.
Exactly. The interim order nahi against.
Sir, I am selection ହେଇଛୁ ଆମେ କିନ୍ତୁ ପାଇ ପାରୁନୁ.
ପାଇବେନି because case is pending. Is it that the जोथरे selection ହେଇଗଲା the read should be disposed of? Something is under challenge. challenged before the High Court. It is for the petitioner to decide. Suppose you want to oppose the amendment, you can oppose it.
No, I'm not opposing.
Pendency.
I'm not opposing. my lord.
Pendency will hurt you if there is an interim order against you. Now you are saying that there is no interim order.
No, my lord.
So, what stakes you have? I don't understand.
Sir,
Why
I'm
is opposing? They are they seeking time for filing an amendment petition.
This election is to distribute the.
Sir, you are a conferee of the state largesse. It has been conferred on you. Beyond that, nothing. No more, no better right you have as far as the petitioner is concerned.
Sir, policy decision ଅଛି ଯେ women group କୁ first priority ଦିଆହବ.
Whatever it may be, am I addressing on merit? So petition is pending since 2023.
Again.
And in 25 May, suddenly it becomes April, it becomes May, it becomes urgent at the instance of the respondent. So if you have any grievance for any modification, you have to file that. You say that there is no interim order. Mrs. S. Rona for the petitioner. Opposite party AGA jahan je asibe tanga na likhibe na. AGA blank. Opposite party AGA blank third time. Mr. Subhash Chandra Pradhan for OP number
6. Opposite party 6.
OP 6. The learned counsel for the petitioner 6 time further time to file amendment petition. As prayed for list on 25/6/2025. The learned counsel for the opposite party number 6 objects for adjournment. Yes. What is the relevance of somebody opposite party of objecting the state? Yes, next.
Item 38.
Yes.
38.
Then item 38.
Today, we have been served a counter affidavit in the first item by the OP4.
I to WPC 7851 of 2025.
We have been served today, just a few minutes ago.
Mr. Subir Palit, Senior Counsel, instructed by Mr. Kejriwal or Mr. Misra?
Mr. Kejriwal.
Mr. Misra. Mr. Misra for the petitioner. Anyone for OP?
OP, Mr. Anand Swai has appeared. He served me a counter.
Okay.
OP4.
OP4, Mr.
Rest of the OP is
OP1, ACHA blank कर दियो.
Sorry.
और एक correctly लिखिए देखिए, ताकि list देखिए लिखिए.
Anand Swai has appeared for the OP.
Mr. Anand Chandra Swai,
OP4 in the first and second items. First and third sub item.
Same 7851, 7907.
7907 रे appear करचंती.
7907.
आ बाकी गोड़ारे OP4 पे के appear करी नाहंती. Even though notice has gone, our state is an opposite party in all.
The noting has gone 80 not back from OP.
Asu. July ra asu. July first week ra asu.
The counsel for the learned senior counsel submits that he has been served. Submits that the learned instructing counsel has been served with copy of the counter by OP number 4
today.
In court. So,
I'll file my reaction.
Further time may be granted to obtain instruction.
My reaction.
And file rejoinder in response to the counter.
Second week of July.
On consent, list on 7 July
7 July.
Monday.
Again, interim to extended.
Interim order dated so and so shall continue.
In all the matters.
In the next day.
In all the matters, there is interim order.
There is no interim order in the second case.
Second
case, there is no interim order.
WPC lekho to 6659.
There is no interim order, it is only tagged.
Mr. Anindya Kumar Misra.
Baki goda interim order order achi interim.
You have filed, you have received copy of counter?
No counter has been filed.
So Anindya Kumar Misra for the petitioner, state OP1, OP4 blank. Non-appearance mention. So in view of the order passed in 7851 of 2025, connected WPC 7851, list on 7
And the last case is also mine, my lord. There is an interim order.
8 people 2.
बाकी सबुआडे इंट्री ऑर्डर अच्छी
except
those entry orders will continue.
entry model लिखो entry model blank छाड़ दो
Entry order continue हो
नॉले नो entry model लिख दो तब गाड़ी में क्यों दिया
आगे आगे
तो डेट तक there is 7907 and up to the last matter ସବୁଥିରେ entry model ଅଛି
ସବୁଥିରେ ଅଛି
appearance ଲେଖା ହେଇଛି दूसरे की appear करके ଲେଖା ହେଇଛି स्टेट रो बुझिबे की appear करके
Great, good. Urgent copy of that.
Interim order has been passed on 21st of March.
21st. 21 ର entry order ଟା नहीं different date
entry order डेट 21 20 24
हाँ
25
आगे
entry order डेट
entry अलगा अलगा डेट रे अछि किंतु
मो केस का पास्ट अर्लियर सेल कॉपी
Last case का
is what I had submitted to your lordship. Thereafter, my lords, I had brought to your lordship notice the other judgment which they had produced is Altus Uber.
Yes.
Now in Altus Uber, 2 paragraphs, my lords, I will just place them again before your lordships, 36 and 37. Internal page 16 of the judgment.
Yes.
Does your lordship have?
Yes, please. 36 of Altus Uber.
An action in rem is filed by way of a suit and governed by the provisions of the Civil Procedure Code. The full bench in Golden Progress was conscious of the fact that a suit cannot be filed simpliciter for interim relief, as they have expressed their conclusion in paragraph 78(2) by saying that an action in rem must be for recovery of a claim. This can only mean that a decree must be sought, as a decree is the only manner in which a claim can be recovered in a suit. Then paragraph 37. This court in African Eagle was considering an action in rem where the prayer in the suit was confined to seeking security pending arbitration, that is for interim relief only. The suit was not for recovery of the claim at all, and no final relief of decree was sought. It is in this context, this court, relying upon the settled legal position reiterated in Balco, held that such a suit only for interim relief is not maintainable. The present suit of plaintiff is not such a suit. In fact, in the case of African Eagle, this court observed in para 21 that full bench in Golden Progress, in my view, has not considered a situation like in the present suit as to whether a suit seeking a final relief at the interlocutory stage is maintainable or not. Consequently, the judgment of African Eagle is distinguishable on facts, because the suit was only for interim relief and no decree for recovery of claim was sought. Now, what is the present suit, my lords? The present suit is again for interim relief, post-amendment. It is an interim relief in aid of the Gujarat proceeding.
Yes.
And that is why, my lords, I want your lordships to see the judgment in African Eagle.
Yes.
Kindly take para 18.
Para 80 you are referring.
No, 18.
18.
Before that, your lordship may take para 17 at page 8 of that judgment, para 17, 7th line from the top. The sentence beginning, what the court held.
Yes.
That's it. The title. Para 17, 7th line. What the court held. What the court held was an action in rem in Admiralty jurisdiction for recovery of the claim and arrest of the vessel, where the parties have agreed to submit to the dispute to arbitration can be maintained. And in such case, if by way of an interim measure the vessel is arrested or security is provided to obtain the release of the vessel, matter shall proceed with in accord with Article 7 of the International Convention on Arrest of Ships 1999. In Golden Progress, the plaintiff had filed a suit for the purpose of recovering an amount of aggregate of $46,000 together with interest thereon and costs due and payable to them by the second defendant, and B, in the alternative, for securing the said amount pending the commencement and outcome of the arbitration proceeding to be initiated in London against the second defendant. The plaintiff had claims against the defendant of the charter party, and the defendants not having made the payments, the plaintiff filed the suit. It is necessary to emphasize that the primary prayer for a decree in their favor for recovery of $46,000 or 46,000, and only in the alternative the plaintiff pleaded that in view of the arbitration clause, they are entitled to an order of arrest of the ship to secure their claim in arbitration, which was to be commenced. In the said judgment, the full bench considered the apex court judgment in the matter of Bhatia International and held that the conclusions drawn to Bhatia by the apex court and the law declared therein do not lead to the conclusion that an application under Section 9 of the Act is maintainable for the arrest of a vessel for obtaining security for an award that may inure for their benefit in the foreign arbitration. Thereafter, my lords, your lordship may the next page at the top, though the court has not said in so many words, I would say that such an action in the Admiralty jurisdiction cannot be only for security pending arbitration as the sole relief. The reason for that, in my view, is the ship may be arrested in the Admiralty jurisdiction only to acquire assumed jurisdiction or to obtain security for satisfaction of the claim when decreed or in execution of a decree. And once the vessel is arrested, the suit must proceed to trial against the owner as in any other suit. Thereafter, come to paragraph 21. Reading the Golden Progress judgment holistically, it would show that the Admiralty Court has no jurisdiction to arrest a ship or keep a ship under arrest when a party sought to invoke the Admiralty jurisdiction not to obtain the hearing and determination of claim, but for the purpose of obtaining security for an award for arbitration proceedings. Like in the Golden Progress matter, if a party files a suit in which a preliminary prayer was for a decree, it is quite possible that the defendant may give up the arbitration and proceed to defend the suit, in which event the suit shall be proceeded with, and it cannot be said that the High Court had no jurisdiction to deal with such suits. This means that the plaintiff may not be keen to go on with arbitration, but may want to go on with the suit, and the defendants may also sing along, in which case the suit has to be proceeded with. At that stage, the plaintiff cannot say that the High Court had no jurisdiction to deal with the suit, but to refer the matter to arbitration. However, in such a suit, if the defendant comes and insists that there is a valid arbitration agreement operative and capable of being performed, and if that is so, the court shall have no discretion but to refer the parties to arbitration agreement. It is for this reason in Golden Progress, the full bench in its concluding paragraph said, an action in rem for recovery of claim and arrest of the vessel where the parties have agreed to submit the dispute to arbitration can be maintained, and in such case, if by way of an interim measure the vessel is arrested for the security provided to obtain release of the vehicle, matter shall be proceeded with according to Article 12 of the International Convention. But what has been underlined here is for recovery of the claim. That your Lordship might kindly take note of. Thereafter, para 22. The expression used in an action in rem in Admiralty jurisdiction for recovery of claim and arrest of vessel. Recovery of claim can only be in the suit where the plaintiff has sought a decree. Recovery of the claim, in fact, the full bench has quoted, has not disagreed with what the English courts have held. To the English courts have opined that where the plaintiff has sought to invoke the Admiralty jurisdiction and not to obtain the hearing and determination of claim, but for the purpose of obtaining security for an award for arbitration proceeding, such an action cannot be maintained.
Yes.
Your Lordship can thereafter take para 29.
Yes.
Therefore, I am in agreement with Mr. Rambhadram's submission that Golden Progress case is not applicable to the present facts of the case, as there is no prayer for decree or substantial relief in this case. In Golden Progress, the suit itself was primarily for a claim and a decree against the defendants therein. The full bench, in my view, has not considered a situation like in the present as to whether a suit seeking a final relief at an interlocutory stage is maintainable or not. Therefore, we'll have to consider whether the suit itself can be proceeded with or the plaint should be rejected in the light of Balco. In the Balco judgment, the Apex Court had in no uncertain terms held that the inter-party suit simply for interim relief pending arbitration would not be maintainable. The Apex Court held that in order to claim an interim relief, the existence of a pending suit is necessary. The Apex Court opined that pendency of the arbitration proceedings outside India would not provide a cause of action for the suit where the main prayer is for interim relief, and in a suit where it is only for interim relief and security pending arbitration, interlocutory reliefs and final reliefs would be identical, and such a suit would not be maintainable because an interlocutory injunction can only be granted during pendency of the suit claiming the relief, which is likely to result in a final decision upon the subject in dispute. Now, in the present case also, the arbitration is in Singapore, foreign land. The Apex Court further held that a suit would be maintainable only on the existence of a cause of action which would entitle the plaintiff for substantive relief claimed in the suit. And the interim relief must be part of the substantive relief to which the plaintiff's cause of action entitled him. The court further said that these ingredients will be missing in a suit claiming only interim relief during pendency of the arbitration proceedings outside India. Since the dispute is to be decided by the arbitration, no substantive relief concerning the merits of the arbitration would be claimed in the suit, and the plaintiff's only claim would depend on the outcome of the arbitration proceeding in a foreign country over which the courts in India would have no jurisdiction. The cause of action would clearly be a contingent speculative. There would be no existing cause of action, and the plaint itself would be liable to be rejected under Order 7, Rule 11A of the Civil Procedure Code. What in effect the court has said was no interim relief could be granted unless in aid of an auxiliary to the main relief that may be available to the party on final determination of rights in a suit. Thereafter, para 37.
So here one question that may arise, because your ground for Order 7 Rule 11 is 11C. But apart from 11C, you are also saying that 11A would be applicable here.
Yes. But if the amendment is allowed, it would be hit by 11A.
11A. And 11C, as far as the amendment, change in nature and character, if that hurdle is not crossed, then the court need not go, order 6 rule 17, I think. Order 6 rule 17 is?
The court may at any stage of the proceeding allow either party to alter or amend his pleadings in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties. Provided that no application for amendment shall be allowed after the trial has commenced unless the court comes to a conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial.
Yes.
Now, the purpose for determining the real questions in controversy is either going to be adjudicated in arbitration in a foreign court or in some other proceeding, not here. So how can the amendment be envisaged in the circumstances?
So,
and this, my lord,
so
this position.
Applying that LIC test.
Yes.
LIC test, if order 6 rule 17, that barrier is not crossed, then the court need not go to this order 7 rule 11.
Correct. If the plaintiff, your lordship is convinced that the admission amendment itself
will not pass the
need not go.
Will not pass the scrutiny of LIC tests.
Correct.
41.2, 41.3.
Absolutely. It has to be rejected on that ground. And once the amendment goes, the plaintiff.
I mean, in a way, the court will not have any scope to go into whether this order 7 rule 11.
Not necessary, because it becomes redundant thereafter. If the amendment gets rejected, nothing survives. And all this exercise I am going through is to show that the amendment itself cannot be permitted.
That is your answer to 11A. I mean, in certain cases, 11A is not satisfied, then it has to go like this particular Africa eagle. African eagle. Yes, please carry on.
I was at para 37.
Yes, 37.
The provisions with regard to the temporary injunction and interlocutory orders are contained in Order 39 and Rule 40. Order 40. In order to claim an injunction, the existence of a pending suit is prerequisite. It is in this background that one has to examine as to whether an inter-party suits for interim relief during pendency of the arbitration proceedings outside India would be maintainable.
Yes.
In our opinion, pendency of the arbitration proceeding outside India would not provide a cause of action for a suit where the main prayer is for injunction. Now kindly take paragraph 48. So far as the Indian law is concerned, it is settled that the source of a court's power to grant interim relief is traceable to Section 94 and in exceptional cases, Section 151 CPC. The Civil Procedure Code presupposes the existence of a substantive suit for final relief, wherein the power to grant an interim relief may be exercised only till disposal thereof. Thereafter, para 51. In these circumstances, the Apex Court has held that an inter-party suit simply for interim relief pending arbitration outside India will not be maintainable. And unless the dispute is decided by the arbitrator, cause of action will clearly be contingent and speculative, and there will be no existing cause of action. The plaintiff is bound to be rejected under Order 7, Rule 11A. So, as far as the amendment application is concerned,
just kindly read further 51. In my opinion, last line.
In my opinion, the court's jurisdiction to arrest the ship in an action in rem should not be exercised for the purpose of providing security for an award, which may be made in an arbitration proceeding that is maintainable because the purpose of the exercise of the jurisdiction is to provide security in exercise in respect of the action in rem and not to provide security in some other proceeding like an arbitration proceeding. If the plaintiff invokes the jurisdiction of the court to obtain arrest of a ship as security for an award in an arbitration proceeding, the court should not issue a warrant of arrest. Now, my lords, had this prayer been made at the first instance, had the plaint been framed in the manner it is now proposed to be framed, the order of arrest would not have been made.
You have your reference to this case law. Have you finished or any more case laws?
No, the other case.
Yes. No, before that, should you, since you have already raised this cited MB African Eagle.
Yeah.
So now, can you go through that whatever has been pleaded in the amendment petition?
Correct. I will do that. Now, if your lordship has the amendment application.
Amendment application is IA?
IA number 15 of 2025.
IA 15 at flag I, my lord. I for India.
Yes.
Now, my lords, if your lordship sees in the original plaint, in the prayer, there is no reference to Gujarat Admiralty. The plaint also is silent about the Gujarat case.
Yes.
Now, in the present application, they introduce Gujarat Admiralty suit for the first time. In para 6, they say that the maritime claim in Gujarat is for 428 crores.
Yes.
Thereafter, in para 7, they say that the value of the vessels which are subject matter.
Yes, please carry on.
Now, in para 7, they say that the value of the 5 vessels that are sought to be arrested in Gujarat or which are subject matter of the Gujarat suit is so and so value, 296 crores. And then they say that there is a shortfall in paragraph 8. Hence, in paragraph 10, they say that the vessel which are subject matter of the Odisha suit are valued at 153 crores. And in 11, they say that the estimated total market value of the vessels, which is then added to the vessels of Gujarat, covers the plaintiff's entire claim. So, my lords, you file a case in Gujarat, whatever be the nature of the case, you seek to recover from the defendants in the Gujarat suit a particular amount of money. But since that claim cannot be satisfied according to you in Gujarat, you file another suit in Orissa where you seek to realize the balance amount in aid of the Gujarat suit. Is such a legal proposition tenable in law at all? Para 13 may be seen. While the Parliament was alive to the issue and provided for transfer in terms of Section 15 of the Admiralty Act, this could not possibly have the Parliament's intention that plaintiff initiate the same proceeding for the same cause of action and the claims before different courts. This would evidently risk inconsistent finding and waste the judiciary's invaluable time. And now, my lords, they filed for transfer, that got rejected, and what they could not do directly, they are seeking to do indirectly by way of this amendment. Now, kindly going on with the application, Kindly come to para 15. Third line. However, on account of the time passed and though the review petition is pending, the petitioner seeks to amend the present plain to seek a declaratory relief and consequential relief. Kindly note the word consequential relief for arrest and sale in aid of the prior instituted administrative proceeding before the Gujarat. So not only declaratory, but consequential relief of arrest and sale of what? Of the vessel. Valued at what? 153 crores. Now kindly take the next page, para B. Now, these are the prayers. The prayer begins at paragraph 18. On that same page, paragraph 18. The file?
18.
Huh?
18B.
18A I got the In light of the above, the plaintiff seeks to amend the plain filed in the suit before the Honorable Court seeking inter alia the following reliefs. The Honorable Court be pleased to declare that the defendant vessels are connected with and subject to the same maritime claim arising out of or in connection with the transactions under the settlement agreement as in the Gujarat suit. I have no quarrel with this prayer. It's a declaratory relief that is seeking. Now come to B. That the vessel, Ocean Jade, that is one of the defendants, present at Paradip Port, Odisha, or at such other location within the territorial waters of India, be arrested, detained, condemned, and sold through the bailiff under orders and directions of the Honorable Court, and the sale proceeds be applied towards satisfaction of the plaintiff's claim in the Gujarat suit. Same thing with C, with the other vessel, in respect of the other vessel. So they are seeking arrest, detention, condemnation, and sale as a consequential relief of the vessels, which are valued at 153 crores, according to them, going by their own admission. Now, kind to come to D, that pending hearing and final disposal of the Gujarat suit, defendant vessel so and so be arrested by a warrant of arrest under the orders of this Honorable Court and be detained, restrained from sailing out of territorial waters of India. Now come to E. That pending hearing and final disposal of the suit, the Honorable Court be pleased to issue a direction for conducting sale of defendant vessels, so and so and so and so, by public auction advertised in the public notice column of Indian Express and one local newspaper for commanding in large and so and so. Thereafter, F. The pending and hearing the final disposal of the suit, the bailiff be directed to immediately upon sale of the defendant vessel and to hold the sale proceeds on behalf of the Admiralty Register and to deposit the sum with the Admiralty Register to the credit of the plaintiff's claim in the Gujarat suit after deducting the expenses of sale incurred by him. Now, in my humble opinion, paragraph 7 of the schedule, which is attached to the application.
Page 12. My lord, page 12.
Paragraph 7, last but one page of that application.
Because schedule you have to go each paragraph. Whichever according to you is amounting to change of nature and character, go serially. Schedule paragraph 1 to 8.
Everything, right from the very beginning. Page 9, schedule 1. Kindly see A, B, C of para 1. Your Lordship wants it, we have a compilation by way of a table. What was there and what is sought to be, I can pass it on to you. We have that comparison. What was there and what is now sought to be introduced.
And provide the soft copy also.
Soft copy.
Soft copy of the word file to the
Yes,
person.
yes. We'll do that. We'll do that. Well, this very much, you know. If your lordship sees the table, what was there and what is now sought to be introduced. And that Gujarat thing your lordships will find is an introduction for the first time by way of amendment. Yes, I've extracted the entire thing. I will not bother your lordship going through the entire thing. Save, except I will just show the schedule, para 7 of the schedule to the amendment application.
Yes.
In para 35 of the plaint, the plaintiff has paid fixed court fee of INR dash and hence the present suit is sufficiently stamped, be deleted, and the plaintiff values its relief at rupees 20 lakhs. Therefore, the ad valorem court fee to be paid by the plaintiff is so and so. He has already paid 75,000 as court fee and hence the present suit is sufficiently stamped. What is the basis for this 20 lakhs? From where has he plucked out this figure of 20 lakhs? From 428 crores, now you say the defendants are valued at 153 crores. You said 428 crores and got my vessels arrested. Then you climb down to 153 crores. And while paying court fee, you want to pay on 20 lakhs. On what basis? And this, my lords, has been answered. Your lordships, I'll just show two judgments on this point. We had a compilation, my lords, you're giving it now. I will refer to some of the judgments and maybe a couple of judgments which are not there in the compilation.
Yes.
Page 13, there is a judgment which I want to rely upon first.
Yes.
Page 13, Kamleshwar Kishore Singh versus Parasnath Singh, 2002 Supreme Court. Kindly take paragraph 8 of that judgment.
Para 8.
Right. This is the principle, and Supreme Court has decided this. Thereafter, I'll come to the exact position. It is well settled that the court fee has to be paid on the plaint as framed and not on the plaint as it ought to have been framed unless by astuteness employed in drafting the plaint, the plaintiff has attempted at evading payment of court fees, or unless there be a provision of law requiring the plaintiff to value the suit and pay the court fee in a manner other than one adopted by the plaintiff. The court shall begin with an assumption for the purpose of determining the court fee payable on the plaint that the averments made therein by the plaintiff are correct. Yet, an arbitrary valuation of the suit property having no basis at all for such valuation and made so to evade payment of court fee and fixed for the purpose of conferring jurisdiction on some court which it does not have, or depriving the court of jurisdiction of some depriving jurisdiction which is would otherwise have, can also be interfered with by the court if it is the substance and not the form which will be determinative of the valuation and payment of court fee. The defense taken in the written statement may not be relevant. I will not go into that. The next judgment that I rely upon is a judgment of our own High Court, Orissa High Court, my lords. 2011 SCC online, Orissa, page 170. Yes. Para 15, my lords. Yes. Also, even though provisions under Section 74C of the Court Fees Act provides for determination of valuation of the suit by the plaintiff at his option, but such valuation cannot be arbitrary and must have some relation with the real market value of the property at the time of institution of the suit. Referring to a number of authoritative judicial pronouncements, this court held in Kedarnath so-and-so on a close and composite reading of the provisions of Section 4C of the Court Fees Act, along with the above noted case laws, one can comfortably infer that in a suit for declaration coupled with consequential relief, the plaintiff, as per the provisions of 74C of the Court Fees Act, can value the suit at his option, but such valuation cannot be arbitrary and must have some relation with the real market value of the property at the time of institution of the suit. Yes. The next judgment is a very recent judgment. And I have shown to your lordship that there is a prayer for consequential relief, even in the amendment. Yes. The next judgment is a very recent judgment delivered only last week, my lord, by the Gwalior bench of the Madhya Pradesh High Court. Para 10. As your lordship got it. As per the law settled. As per the law settled, the allegations of the plaintiff, including the substantive relief claimed, must be the basis for settling the court fee payable by the plaintiff. But where the plaintiff attempts to undervalue the claim and release, the court has to intervene. In doing so, concept of real money value forms integral part of court's inquiry, where relief sought has real money value, which can be objectively ascertained. In this connection, subsection 4C of section 7 of the Act, which relates to computation of court fees payable in certain suit, envisages that to obtain a declaratory decree or order where consequential relief is prayed. In the present case, the petitioner plaintiff has sought declaration for protection of possession on the basis of agreement to sell, which itself is not the basis of any title. The relief for such declaration is an independent relief and connected with the relief of title, meaning thereby the relief sought by the plaintiff on the basis of the agreement automatically includes the question of title along with possession, and for such independent relief, the petitioner will have to pay the court fee on the basis of the amount of consideration mentioned in the agreement. Yes. So, my lord, your lordship sees, my lord, I would put it this way, my lords. Having obtained the order of arrest, now the plaintiff is adopting various manipulative processes which are tainted with malafide, which, while without payment of the court fee, without meeting his obligations as a litigant, he wants to cling on to the relief which he has snatched away by misrepresentation to this honorable. The next judgment which I would rely upon on the compilation on the question of amendment, the first judgment in my compilation, Radha Goel versus Gaurav Goel, your lordship may take para 6. If the facts are in para 4, your lordship may kindly see the para 4 first. Does your lordship have that?
Yes, please.
The suit was instituted on 31/7/14 and the trial has got prolonged on one ground or the other. It appears that by the order dated 21/8/21, the then learned trial court directed the petitioner plaintiff to mention separate valuation of the property in the plaint, which was reiterated by the order dated so and so as well. Purportedly in compliance thereof, the petitioner plaintiff filed an application under Order 6, Rule 17, CPC, but without deciding the same, suit for the petitioner plaintiff was rejected by order dated so and so. The petitioner plaintiff first filed regular first appeal number so and so, which was eventually disposed of by so and so, directing the learned trial court for a fresh consideration of Order 6, Rule 17 filed by the petitioner. The said application came to be dismissed by the learned trial court by order dated 22/11/23. Unrelenting plaintiff petitioner filed a third application under Order 6, Rule 17 on 15/12/23, which was dismissed by the learned trial court by impugned order dated 15/1/23. Evidently, the learned trial court by order dated 14/9/21 found that the valuation of the suit had not been done by the petitioner plaintiff in accordance with the law for the purposes of jurisdiction and payment of court fee. On being foretold about such defects, first application under Order 6, Rule 17 of the CPC was moved on 19/11/21, and after advancing arguments, second application was moved on so and so. Thereafter, your lordship may come to para 6. Your lordship may directly come to D. 6D.
Yes.
Plaintiff has deliberately undervalued estimate of relief in para number 11.8.1 and 11.8.2 in the present application, after estimating it at a much higher value in the first application as well as in the second application without any reason. In the first and the second application, estimation of income of the business of Gopal Ice Cream was valued at rupees 60 lakhs since 2010. However, in order to avoid payment of ad valorem court fee on the same, plaintiff has strategically and with malafide intent reduced estimate of the said relief to rupees 1,000 only. Similarly, plaintiff has reduced estimation of gold ornaments and cash amount from rupees 25 lakhs to rupees 50 lakhs, respectively, to rupees 2,500. This shows malafide intent of the plaintiff to deliberately undervalue relief in order to avoid paying higher court fee as per Section 7 of the Court Fees Act. Order 6, Rule 17 clearly avoids amendments made with malafide intent or dishonesty. Now, kindly take para 36. Para 7, they have quoted the judgment of the trial court.
Yes.
Para 36, page 6. The quoted para 36. In the plaint initially filed by the plaintiff had assessed the valuation of the suit for the purpose of jurisdiction at rupees 1.5 crores for relief of partition, possession, and rendition of accounts, and undertook to pay requisite court fee for determination of the same.
You are reading para 7 of the
para 7 re court kora heichi gota judgment. Taro 36 parata. Page 6.
Quoted paragraph 36.
Page 6 re.
Yes.
In the plaint, Has your lordship got that?
Yes, please.
In the plaint initially filed by the plaintiff has assessed the value of the suit for the purpose of jurisdiction at the rate of rupees 1.5 crores for relief of partition, possession and rendition of accounts and undertook to pay requisite court fees after determination of the same by the court. Later on, by way of amendment application, plaintiff tended to bifurcate income from business Gopal Ice Cream to the tune of rupees 60 lakhs since year 2010 and gold ornaments, cash amounts, rental income to the tune of 25 lakhs, rupees 50 lakhs and rupees 60 lakhs respectively. By way of present application, plaintiff assessed income from business Gopal Ice Cream since 2010 to be arbitrarily rupees 1,000, gold ornaments, cash amount and rental income since year 2010 to be collectively rupees 2,500. Plaintiff has not disclosed any reason for change of this valuation from total of rupees 1 crore 95 lakhs to rupees 3,500 in aggregate of movable properties and prima facie motive of the plaintiff in arbitrarily valuing these reliefs to the tune of rupees 3,500 in aggregate appears to be a mechanism to escape from payment of ad valorem court fees on the above relief, on the said reliefs, which cannot be permitted. Next, your lordship takes para 8 at page 7.
Yes.
Unhesitedly, the aforesaid observations clearly bring out the conduct of the petitioner plaintiff in the open. It clearly appears that in order to avoid payment of ad valorem court fee, the petitioner plaintiff is making all sorts of attempts to hoodwink the process of law by avoiding putting a fair and just value to the reliefs claimed by her. Suffice to state that although the petitioner plaintiff by way of the proposed amendments had apparently valued each relief with regard to the share the property is putting a different value, and though the overall relief is rupees 5 crores 94 lakhs, she has again elected to pay fixed court fee of rupees 20 and valuing the suit for permanent injunction at rupees 130. There is a clear attempt to evade payment of ad valorem court fees under Article 17(4) of the Court Fees Act, and the proposed amendment being not warranted by law cannot be allowed. The next judgment on this point is at the very next page. This is Punjab Haryana High Court, Jatinder Pal Singh. Your Lordship takes para 2 and also take note of the relief that was claimed. Last line. He has also claimed damages for the consequential loss as suffered by him and further prayed for issuance of mandatory injunctions by directing the defendants to grant him all the service benefits as well as the compensation for the period for which he was denied the extension of his service and to pay the damages along with interest thereon. So, well, let's even assuming for the sake of argument that the plaintiff were to argue before your lordship, which they have not. But even if they are saying that it's a mere declaratory relief and a relief for injunction, what kind of injunction? You want impounding of my ship? You want sale of my ship? So, my lord, it's a mandatory injunction that you are seeking. So, if it's a mandatory injunction, what would be the court fee payable there? It would be ad valorem to the value of the property. And that is what has been decided. Here, your lordship sees at page 3 of the judgment.
Your contention is assuming that the amendment is to be allowed. Still, that would not end up in reducing the court fee.
Yes. The entire court fee amount is payable.
It's payable.
And the suit cannot be valued at rupees 20 lakhs. There is no basis, no rationale for once having said that the two vessels are 153 crores, my total claim is 428 crores, and this is a suit in aid of the claim of rupees 428 crores, you can by no stretch of imagination value your suit at rupees 20 lakhs. So this is the mala fide. which I am trying to point out to your lordship, and which, my lords, Life Insurance Corporation also has said in so many words is impermissible. So, my lords, looking at it from any point of view, because your lordship sees from the reliefs that have been claimed, the court fee payable is on the total claim amount of 428 crores. Now, for that, the plaintiff was granted a time. That time has expired. There is no prayer even for extension of that time. So, my lords, what happens to the suit? Can the suit survive? A formal order, of course, is required to be passed by the court that the suit, but such order will take effect from the date it has become such. That is 16/4/2025. So the intention which they have very latently put forth before your lordship is that we do not want to pay the court fee. In the initial plaint also they said so. Now also they say so. And the only very clear that picture that emerges from the sequence of events, the only intention is to keep the arrest alive without payment of the court fee. And that is why the amendment has been put in place. And that is exactly the reason why I submit before your lordships that this is abuse of the process of law. Now, it's coming back to the judgment which I was citing before your lordship. Para 5. Para 5. Just before para 5, they have taken...
You are referring to Radha Goel.
This is no matter. The subsequent judgment, that is Punjab Haryana Jatinder Pal.
Jatinder Pal.
Jatinder Pal, it begins at page 8. I am at page 11.
Yes.
Page 11, my lord. In para 4, end of para 4, they take note of Life Insurance Corporation. And thereafter, they, in para 5, this is what they say. However, the above raised contentions are devoid of any merit because, as mentioned earlier, the issues have been framed in the aforesaid suit long back on 18/3/21 and then on 17/3/22. The plaintiff had tendered his affidavit along with several documents in his evidence, while appearing as his own witness, whereas he has moved the application, annexure P11, on 9/2/23. Merely thereby, the trial has already commenced in the said civil suit before filing of the above said application. The verdict rendered by the Apex Court in Life Insurance Corporation of India is of no avail to the plaintiff, because though it has been observed that all the amendments are to be allowed which are necessary for determining the real question in controversy, provided this do not cause injustice or prejudice to the other side, and this is mandatory, as is apparent from the use of the word shall in the later part of Order 6, Rule 17, but in the instant case throughout, in the aforesaid application, the plaintiff has not whispered a single word to explain how the proposed amendments would be necessary for determining the real question in controversy between the parties. Now, what is the real controversy? Real question in controversy between the parties here, my lords? You want satisfaction of a claim made before Gujarat, where I am not even a party. And for that, you take an ex parte arrest of my vessel. You want it to be sold, for which you have already made an application, and you want the money to be taken and put as security for the Gujarat claim. Rather, as regards the prayer of the plaintiff for considering the affidavit and documents tagged therewith as a part of his pleadings, it is well settled that, that the evidence need not be pleaded in the pleadings. So far as the prayer for replacing the words damages with consequential relief in para number 1 and 3 of the prayer clause and for the proposed amendments in para 24 and 32, qua the valuation of the suit for the purpose of court fee is concerned, the same would not be permissible in the circumstances when conceitedly the application moved by the plaintiff defendants under Order 7, Rule 11 CPC for seeking rejection of the plaint on the score of non-fixation of proper court fee on the sale is pending adjudication before the trial court. And rather, the above mentioned proposed amendment seemed to have been sought in view of the aforesaid application as filed by the defendants. Exactly the same case here. As a sequel to the foregoing discussion, it follows that the impugned order under Annexure P60 does not suffer from any illegality. Not necessary. So here also your lordship sees that I filed the application for Order 7, Rule 11. They did not pay the court fee within the time fixed by the court, and thereafter came up with the application for amendment. Now, the next judgment, my lords, which I page 44, your lordship. I will not cite those Nawab John, etc. Those are there in the citation. I have already they have been placed before your lordship. But this Zubair, I will place page 44 of that compilation. Page 44, your lordship has seen, Zubair. Kindly come to para 8 at page 47. Now, before I start reading this para 8, your lordships will recall that one of the prayers of the plaintiff was that kindly defer the payment of court fee till I realize the amount in arbitration. Now, in that context, kindly see what has been stated by the Supreme. We inquired from the counsel for the respondent plaintiff as to how the question of payment of court fees can be deferred to a stage of final adjudication, and as to how the claim of the respondent plaintiff for damages can be put to trial and the payment of court fees thereon be deferred and be directed to be paid only if the plaintiff succeeds in such claim. We further inquired from the counsel for the respondent plaintiff whether or not, if the same was permitted, the plaintiff in each and every suit for recovery of money would contend that the payment of court fees thereon be deferred to the final stage, with the plaintiff being liable to pay court fees only if he succeeds, and escaping such payment if there were to be unsuccessful in his claim. Needless to state, no answer was forthcoming. The counsel for the respondent plaintiff, on the contrary, referred to root saying so and so, so and so, so and so, but could not explain the relevancy thereof to the question raised by us. He, however, contended that the appellant's defendants having not challenged the order dated 29th January 2014, the same cannot be made the basis for deciding this appeal. In our opinion, the question of payment of court fees cannot be deferred to a stage of final decision unless entails any factual adjudication in trial. The division bench of this court in Sahara, India, while setting aside an order of the single judge, granting exemption to the plaintiff in suit for recovery of damages from payment of court fees and directing that in case the plaintiff succeeds, the court fees will be deducted from the decretal amount, held, 1, that Section 4 of the Court Fees Act, as applied to Delhi, puts a complete embargo on the power of the court to proceed upon with or act upon a document of any kind, including a plaint, in the suit unless it bears the prescribed court fee. The same is here. Though Order 7, Rule 11 of the CPC empowers the court to, in cases of grave injustice or hardship, extend the time for payment of court fees, but neither the Court Fee nor the CPC empower, Court Fees Act nor the CPC empower the court to grant exemption from payment of prescribed court fee. The law also does not provide for deferment of payment of court fee till the decision of the suit and recovery thereof from a decretal amount. If the plaintiff is unable to pay the court fees, the only course available is to apply to sue as an indigent person. Else, the suit cannot be tried without payment of court fees. Even the proviso to section order 7 rule 11 of the CPC does not. Then para 12. Now, para 11, just last 4 lines. The last 4 lines, sentence beginning thus as per the newly added sub. So, my lord, the contention, my lords, that all this will be decided in the trial, that question doesn't arise. Suit itself is not instituted as of now. The court had utilized its discretion, granted them some time, that time is gone. Para 12. The fact of the matter remains that the appellant defendant sought rejection of the plain on the ground of the suit insofar as the relief for damages having not been valued at all for the purposes of court fee and the appropriate court fee having not been paid thereon, but the learned single judge refused to decide the same. The said refusal of the learned single judge to decide the ground urge for rejection of the plaint, coupled with the deferment while subsequent order dated 29 January 2014 of decision on the said aspect till the time of final adjudication, and which will result in the claim of the respondent plaintiff for damages being put on trial without appropriate court fees being paid thereon, in our view, is sufficient for the appellant defendant to raise a grievance thereagainst in this appeal. Rule 11 of Order 7 CPC in clause B thereof makes, where the court where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time to be fixed by the court, fails to do so, a ground for rejection of the plaint. The purport thereof is that the relief which is not properly valued for the purpose of court fees be not put to trial and should be rejected at the threshold only. The said right of the defendant, to have the said relief rejected cannot be taken away by deferring a decision thereon on the stage of final adjudication. Well, it's a question was put to you yesterday by the counsel appearing for the plaintiff, that what right does because the court fees are matter between the court and the plaintiff, what right the defendant has. The defendant cannot question that. Now here the Supreme Court saying that defendant has every right to object, and that right has to be, and that question has to be adjudicated at the threshold. Now, I am tempted to show one more judgment to your lordship. That is, no, not 7. Res judicata, my lords, etc. Those judgments I have given, I am not bothering your lordship. I have also given the paragraphs number, which I rely upon. But one judgment, my lords, I just wanted to show to your lordship. Your lordship sees there is an application for modification. IA number 16.
Flag J. Flag J.
Flag J.
One interruption that today also I have some assignment. I have to raise. I can't continue the proceeding. So since I'm dictating each day's order, so I'll be.
I'm closing. I'm closing.
Yes.
My part is over. My part is over. In fact, I have nothing further to act. In fact, the modification which they are seeking, that is the other application which is your lordship is presently in session of, because the 3 applications which your lordship is now in session of. One is Order 7 Rule 11 filed by me, application for amendment filed by them, and the application seeking modification filed by them. These 3 applications are the ones which are being heard.
Modification is IA?
IA 16.
16.
Huh? 16.
16.
So my lords, if at all a modification is called for in respect of the order dated 19-3, I would say it requires to be modified to the extent that the indulgence granted by the court to them or the discretion exercised in favor of them is required to be taken away by the subsequent conducts that they have experienced. That is all, my lords, and for that purpose, I wanted to show this judgment. It's not necessary.
That is Pushpalata.
That is that is Bhuta Singh, my lords. Bhuta Singh, paragraph 9 and 10, page 41 and 42. So, my lords, this is the prayer for modification is directly hit by the principles of res judicata, for which I rely upon the other two judgments, that's Pushpalata and if at all, and the modification to order dated 19-3 is warranted, it is required to be warranted by taking away that discretion which was exercised by them, which they have misutilized.
You can place it because
para 9.
that is
Yes,
again,
para 9, page 280, page 41
so
of
this was discussed actually on the first day. This Bhuta Singh proposition, that to what extent time can be
modification
enlarged or what happens after. Yes.
Kindly see, take para
9. Having given anxious consideration.
Having given anxious consideration to the respective contentions, question arises whether the claimants would be allowed to pay the deficit court fee. It is true that section 149 gives power to the court to give time to the appellant to make up the deficiency of court fee when the whole or any part of the fee prescribed under the Court Fees Act to pay court fee on the memorandum of appeal, but has not been paid while presenting the same. But the power of the court is one of discretion and not as of right. Generally, before the appeal is admitted, under Order 41, Rule 9, this court would exercise the discretion on showing sufficient cause for not making the required fee on the memorandum of appeal. The discretion conferred on the court by Section 149 is a judicial discretion. This court is not bound to exercise the discretion unless the applicant shows a sufficient cause for the failure to pay deficit court fee, or he has under bona fide mistake in payment thereof. Mere poverty or ignorance or inability to pay the court fee at the time of presenting the appeal is not always a good ground for indulgence under Section 149. Bona fide mistake on the part of the appellant or applicant in making the deficit court fee may be a ground to exercise discretion in favor of the appellant. It is the duty of the registry before admitting the appeal to point out to the appellant or his counsel that deficit court fee is payable on the memorandum of appeal, and some reasonable time may be given for payment of the court fee. The memorandum of appeal would be returned to do the needful. If the deficit court fee is not made up or presented within the time enlarged under Section 148 CPC, there would be no appeal in the eye of law unless the delay is condoned. If the party deliberately to suit his convenience paid insufficient court fee, the mistake is not a bona fide but one of choice made by the party in making the deficit court fee. In that situation, even after pointing out the need to make the court fee and given time, if the court fee is not paid, the memorandum of appeal is represented within the enlarged time, it will be open to the court either to reject the MOA or refuse to condone the delay for not having showing insufficient cause thereon. Therefore, the court is required to exercise its judicial discretion, keeping the facts and circumstances in each case, and not automatically, for mere asking that indulgence be shown to the party to make good the deficit court fee. In the later event, it is not the exercise of judicial discretion, but showing undue indulgence. After the arguments were heard in the appeal, an impression obviously gained that the appeals would be likely to be allowed, enhancing the compensation. We find that the method adopted by the claimants should not be encouraged. There are no bona fides on their part. The aid of Section 149 could be taken only where the party was not able to pay court fee in the circumstances beyond his control or under unavoidable circumstances, and the court would be justified in an appropriate case to exercise the discretionary power under Section 149 after giving due notice to the affected party. Now, pausing here for a minute, my lords, this is a case where specific performance of a contract, alleged contract, is sought by the plaintiff of 170 crores. He says that I was ready to pay 170 crores. They did not sell the vessels to me. Now, if you were in custody of 170 crores, where was the difficulty on your part to pay the court fee as calculated by the court? So it is not a case that you did not have the money in question. But that was not the situation in this case. Under the relevant provisions of the Court Fees Act applicable to appeals filed by the High Court of Punjab and Haryana, the claimants are required to value the appeal in the MOA and need to pay the required court fee. Thereafter, the appeal would be admitted, the notice would go to the respondents. The respondents would be put to notice of the amount. The appellant would be claiming so as to properly canvass the correctness of the claim or entitlement. The claim cannot be kept in uncertainty. If in an appeal under Section 54 of the Land Acquisition Act, the amount is initially kept low, and then depending upon the mood of the appellant court, payment of deficit court fee is sought to be made, it would create an unhealthy practice and would become a game of chess as a matter of chance. The practice should not be conducive and proper for orderly conduct of litigation. So, if at all a modification is warranted, it should be to aid the defendant who has suffered all this time. Since 19th of March, my vessel has been arrested in a suit which was not even properly constituted. And one more thing I'll just clarify. If your lordship sees the prayer in IA number 16, they do not seek any extension of time. They only seek modification of the order. So my prayer to your lordship would be that yes, the order is required to be modified by taking away the discretion which was exercised in their favor for the abuse of the process of law which they have caused. That is all, my lords. I have... Yes. Yes, Mr. Nanda, what you are saying anything?
No, my lord, I'll just give a brief reply subject to your lordships.
Today we have to finish it because yesterday it took almost.
I'll not take not more than half an hour.
Tomorrow you can
Tomorrow
continue.
your lordships can keep it at 3:30 also.
Second half.
Okay. First half,
your lordship may take it up. Take it up.
Yes. I'll not take more than half an hour that I can may not vouch before your lordship.
The lordship may take it up at 12 or 11, whatever time is.
Maybe when it reaches, we'll take it up. And
that's my only prayer.
The matters will roll over to the next list.
Because
I just need half an hour's time.
My only difficulty is second half I'm already committed.
Yes, yes.
So first half let him know. Huh?
But subject to your lordships, subject to your lordships permission, can I take leave?
Yes, yes.
Lordships would be dictating the order and
yes,
both the side councils.
Now I have the yesterday's, contentions recorded. So I'll continue. In fact, Mr. Padi, you said that you'll have a brief submission.
Lord, of course, Mr. Nanda. Lord, I just don't have to say anything, save and accept. Not this stage. Lord, just tell your lordship 5 minutes, only 5 minutes.
Okay, tomorrow then.
I'll take that, 5 minutes. Only.
Yes.
Of course, before Mr. Nanda, so that Mr. Nanda can also.
Yes. Mukherjee, Learned Senior Counsel, continuing his submissions, this should be IA. IA number 15 of 2025 and IA number 11 of 2025. So Mukherjee, Senior Counsel, Learned Senior Counsel, continuing his submissions in the IA 15, that is in response to the prayer for amendment made by the plaintiff. Since that order is not uploaded, Mr. Mahanti, so because I am having it now, so it can be uploaded. So in fact, Mr. Mukherjee continued his submissions where he left. So I am just reading it out. Relying on paragraph 36 of Alter Suba, it is contended that action in rem must be for recovery of the claim. This can only mean that a decree must be sought as a decree is the only manner in which a claim can be recovered in a suit. Referring to paragraph 37 of CM offshore supra, CM is actually Alter Suba. It is submitted that Rusab Ship International versus Bunkers on Board, MB African Eagle and Freight. Today, in fact, you have again rendered by the Bombay High Court. It was held that the settled legal position is that suit only for interim relief is not maintainable. In African Eagle Supra, the Bombay High Court was considering an action in rem where the prayer in the suit was confined to securing security pending arbitration for interim reliefs only. The suit was not for recovery of the claim at all. The court, relying on the earlier decision in Balco, held that such a suit only for interim relief is not maintainable. It is submitted that the proposed amendments are seeking security for the suit pending at Gujarat. The Learned Senior Counsel also relies on Pradeep Kumar, paragraph 17, to submit that the plaintiff was required to make good the deficiency in court fee by the date fixed by the court, and in the relied upon decision, the plaintiff in fact sought amendment of the plaint seeking reduction in the claim by the date fixed. MST Saidun Isa Khatun versus Gaibandha loan. He further refers to the decision of the High Court of the then East Punjab in the case of Gandamal versus Madan Lal, referred to in Pradeep Kumar, to submit that the plaintiff can reduce his claim and furnish requisite court fee on the reduced valuation within the time extended by the court to deposit the court fee. It is submitted that in the case at hand, after the fatality had already happened, that is non-payment of court fee by the extended date fixed by the court. So before such date, there has been no plea for amendment. Senior Counsel, so in fact, the first part of today's submission also covers this.
African Eagle.
Yes. The Learned Senior Counsel refers to the judgment rendered by the High Court of Bombay in Rusab Ship International LLC versus Bunkers on Board. There will be no spelling mistake. Volume 2014 SEC online BOM 620. Paragraphs 17, 18. Twenty-one mark mark 21 is at page
9.
page 9.
My lord. Para 21 starts from page 9.
The next page actually, Mr. Mukherjee refers to that
My lord.
in the golden progress matter.
Yes, your lordship. Yes, lord. Page 10.
Then para 22. Then para 23 ର underline portion ଅଛି, pencil mark ଅଛି. Para 25 ର underline portion, pencil mark. Then 31. Eight and 49.
37 and 38. My lord.
Sorry?
37 and 38. My lord. If your lordship has marked them.
In African Eagle.
My lord. 37.
37, 38.
And 38 initial part. If your lordship has marked, otherwise it's
37 underline portion, 38 underline portion.
my lord. My lord, the last order of 51. Last paragraph.
Sorry?
Your lordship had said
Can you
last,
do,
last paragraph. 51.
Last
Paragraph, para 51 of that judgment. Your lordship remembers, your lordship asks for reading the entire thing. Para 51, last but one.
48, 49 and 51.
Madam.
The Lord Senior Counsel refers to the decision of the Madhya Pradesh High Court at Gwalior in Ramcharan Goel versus Srimati Kamla Rani Verma. Para 10 and 11, Mr. Mahan.
Madam.
Ramcharan versus Kamla Rani. Paragraphs 10 and 11.
Madam, 10 and 11.
Then he refers to, then the Lord Senior Counsel refers to the decision of this court by a coordinate bench. S. Sek Majnu, SK. Majnu, MAJNU versus Lochon Sahoo. Then colon into bracket 2011, bracket closed, 112 CLT 886. Then colon 2011 to 2011 space SCC space online O capital L capital space ORI 170 paragraphs 15 and 16.
Madam.
Or 15 only.
Madam, 15.
15. Then in the compilation, the sequence should be first Radha Goel.
Yes, your lordship.
So compilation upon index such. Radha Goel versus Gaurav Goel. Then is Jatinder Pal.
Jatinder Pal, yes, your lordship.
Then
Kamaleshwar.
Kishore.
My lord. Nawab John was not referred to today, my lord.
Nawabganj is already there, but you want okay.
Not
Well,
referred.
आपण index ରେ ଯାହା कोन citation ଅଛି paragraph ଅଛି तो देखो HCC online ରୁ reproduce कर देते ये देखी दियो देखो देखिए आपनकर citation रहला just look at it. Referring to the amendment, referring to the proposed amendments as in as contained in paragraph CONTA content, not CONT no. In the amendment petition, it is submitted by the senior counsel that there is no reference to the Gujarat suit in the plaint. It is for the first time it is being introduced in the form of amendment. The learned counsel, then the learned senior counsel refers to paragraph 7, 8, 10, 15 of the IA for amendment, as well as schedule para 7 to submit that the proposed amendments shall result in change of nature and character of the suit that is pending before this court. He submitted that the indulgence shown by the court for payment of court fee in a time extended as directed should not be extended to the extent that the suit is allowed to remain without being dismissed. They submitted that the modification sought for cannot come into the aid of the plaintiff for not paying the court fee.
Modification on the IA 16. Modification IA 16.
Lastly, no, it is also submitted referring to the IA number 16 filed by the plaintiff, that there has been no prayer for extension of time to file the court fee. But to be fair, Mr. Mohanty, if they find that petition extension of time to file the court fee, I mean, it is again now juxtaposed against the prayer of amendment. So that is how strategically they could not have. I mean, it is not far to seek or difficult to guess that why they are not seeking that time. Because once they concede, Mr. Mukherjee, assisted by you and Mr. Acharya or your learned young colleague, you will, I mean, means those petitions actually into shreds or shred those petitions. Once they simply, you are just waiting to provoking them to say that actually, maybe. I was feeling that the last time almost a little bit hint of Mr. Nanda that he will, what he said, he reserves his prayer or something like that. He utilized this language. That prayer, because you are basically, your strategy is that to provoke them, just to make their prayer so that you bounce upon that. Once they say that, then there can't be any, I mean, the amendment is redundant. Paucity of time intervenes. To continue further hearing, the matter shall be listed tomorrow to retain its position in the cause list along with the other leftover matters. I would record Korantu. Mr. Mukherjee provides a comparative chart of the pleadings in the original plaint along with IA number 6, IA number 7 and IA number 10, and the pleadings in IA number 15 seeking amendment. IA number 16 is for
modification.
For modification of the order of 15.
Is for
amendment.
That is 19th of March. 19th of March 2020.
We shall provide a soft copy of this matter.
Yes, yes.
Get it in the pen drive.
Yes. You can take help of the request assistant.
Well, we'll get to it.
Yes. Anything else, Mr. Mukherjee?
The only prayer is that tomorrow in the first step.
Yes, yes. I am also thinking because I don't think I'll be able to. Maybe there is a possibility that I will not be able to sit on Friday.
But it's only first step because second half I have already.
And every day I have some assignment after the court hours, so that is another thing that I can't stretch it also. Because ଆପଣଙ୍କର କାଲି ଅର୍ଡରଟା ରଖନ୍ତୁ 10 କଥା ଏଟା ବାନ୍ଧି ଦେବ ବାନ୍ଧିକି ନେଇଯିବ don't miss any papers. Thank you.